Call the superintendent's workshop to order. It is 12 o'clock on Tuesday, November 16th, and I will turn it over to Dr. Moore.
Thank you, Mr. Chair. We do have one item that will consume most of our time today, which is the interview process for school board representation. We have gone back and forth to create the process. We put out the request for proposal, and today is the opportunity for the board to conduct the interviews. To review the process, Mr. Fagan will highlight the entire process. Mr. Fagan?
Thank you, Soup. Through the chair to the board, good afternoon. We have an action-packed afternoon for you. As you know, we have the RFP, we have the two firms. Sniffen and Smelman will be first, and then Gray Robinson will follow. The schedule is 5 minutes for them to come in and set up, approximately 15 minutes for their presentation. Then we go into the board member questions. If you need copies of the questions, I have here if you need a copy. Also for the
Scoring sheet.
and also if you need the interview guide sheet, I have copies for you if you need those. 10 minutes for follow-up, and then a 5-minute wrap-up. Each board member has already formulated their questions. It'll be approximately 10 minutes to ask your questions and get your responses. And once all the board members are done, there'll be a time period at the end for any follow-up questions. As I said, you have an interview guide. Once you complete that interview guide for each of the selections, we'll collect those. Do the same thing again with the second firm. And then as we go on to the next agenda item, we will go tabulate those scores. And then at the end of that second agenda item, we will come in and announce what firm had the most amount of scores and will be selected. Then it will trigger us to go into the process for negotiating the contract and getting an agenda item for the 29th. And that's it. Any questions? Does anybody need questions or the interview guide?
I have a quick question, but it's for Mr. Barefoot.
Pardon?
It's for you, Mr. Barefoot. How do you suggest that we order how the questions get asked?
I'm going to go District 1, 2, 3, 4, 5.
Okay, thank you. And we're going to do one question, or we're going to do a set of questions?
You have 10 minutes. You can get as
10
many,
minutes to do, okay, got it,
many
thank you.
questions you can fit in 10 minutes, and then you'll have an opportunity to follow up if there's still something that you would like to ask.
Sir. Got it.
Anybody else? Oh.
Yeah, might as well.
So, Dr. Schiff, you can do us a favor.
you
You can
ask
ask
for
all
a
the
copy, right?
questions in your 10 minutes that we
Put these
might have asked, and therefore we can
Yeah,
truncate
so
the
it's
whole
better for
thing.
me.
Oh, so I can pick and choose from anybody's questions then?
Yep, got it.
Hey now. If we don't have humor, Suzanne, what have we got, really?
I don't know, what are you handing out? Oh, I got this thing.
You got both of the score sheets?
Yep.
And you got the questions.
Yep. Somewhere. Let me have a set of the questions, just in case.
Okay, if we're ready. First firm is Sniffen and Spellman, and the attorney who will be coming in doing the presentation is Molly Shattuck. I'll go grab her.
Do they typically bring just one person or more than one from the firm?
Varies. The first one is just Molly.
Okay.
Board members, may I present Molly Shattuck from Sniffen and Spellman.
Make sure that this, can you hear me?
Yes.
Okay, good afternoon. Chair and members of the board, Superintendent, I'm so glad to be here today representing my firm, Sniffen and Spellman. My name is Molly Shattuck, and I would like to go through the outline that I was given of about 5 questions that you wanted some information on to kind of present my firm, our attorneys, and what we offer in education law. So starting out with presenting about the firm Sniffen and Spellman, it was created in 2005. It was founded by Robert Sniffen in Tallahassee, where it still has its main branch of the firm. But since its founding, they've really tried to expand throughout the state, and in 2000, they actually opened 2 new offices, one in West Palm Beach and one in Pensacola. So we see it as a firm that can offer counsel geographically throughout the state. And Robert Sniffen has been practicing education law for 27 years, and it's an area that the firm really focuses on. It's been expanding its bench of education lawyers as well, so that in addition to many lawyers who offer other services that can also be drawn upon for their knowledge and expertise, there are several lawyers at the firm who practice education law, me being one of them. And I'll get into those lawyers in a minute. We have represented over 35 school boards throughout the state of Florida, as well as 6 state university systems and some other, private schools or charter schools, some other education law clients. So there's a lot of interaction with education law issues. In 2010, the firm did start a monthly newsletter, which I'd be happy to sign you all up for if you'd like. That's a monthly newsletter of law alerts specifically in the education law area that will update you on any, interesting case developments or things of that nature, as a way of kind of keeping our clients updated on those types of issues. And it's really an area that I feel passionate about, and several attorneys at the firm really focus our attention on education law issues. Our firm has collectively done over 100 ESE, exceptional student education due process cases. We have lots of experience with exceptional student education. I think you'll find that in the legal arena, a lot of litigation kind of develops in the ESE area as well as in the employment area. We also have a lot of lawyers that specifically focus on employment law in our firm. So those are 2 areas that we're well acquainted with in terms of meeting school board needs. As you may or may not know, I did handle 2 ESE due process cases for the Indian River County School Board this year, both of which the school district prevailed on. So I have had some experience in this county with that. So that's a bit about our firm. And moving on to the attorneys that would be representing the school board if selected. So there's myself, and I'll start off with myself. I have been practicing in the area of education law since 2006, so about 15 years. I am a board-certified expert in education law, and I am currently serving as general counsel to 2 school boards in the state of Florida. One is Hendry County, and one is St. Lucie County. That's one is recent, as you may or may not know, although I did help them as general counsel. When I first started my career, I started under Dan Harrell. He's in St. Lucie, and I actually live in St. Lucie, and I worked with his office for about 10 years, and he's been the general counsel to the school board of St. Lucie County for close to 30 years. He just recently retired, and I have now taken over as their general counsel. So I do have familiarity with serving general counsel needs in this, general area of the state, and this is the area of the state that I live in. I love the Treasure Coast. And some other things about me, I also have been involved with the Florida School Board Attorneys Association for many years. I served on the board of that. I also was a member of the Florida Legal Education Committee, and I've been involved in some other, national school board associations, as well as local bar associations. So I do keep my memberships current with those. And I've also been a speaker for the Florida School Board Association and the Florida Association of School Superintendents. I more recently did one of the FADS trainings for their new superintendents. I've also been a speaker for the Florida School Board Attorneys Association. We have quarterly meetings that I like to attend, and I've been a speaker for them as well. So I do also have experience with doing speeches on issues important to school boards, as well as I have also been doing trainings for school boards on issues that are important to them, such as public records laws, student education, privacy and records, FERPA. I've done trainings on Title IX, including the more recent Title IX changes to the regulations that required changes to all of our district policies more recently. So that's probably enough about me for now. I'll let you know about some of the other members of the firm who would also be providing services, because we do utilize a team approach. And so I would like you all to know that, if you can't get a hold of one of us, there are plenty of other people that can fill in. There's Terry Harmon, who also has been practicing education law for 15 years. He is also a Florida Bar Board Certified Specialist in Education Law. He serves as general counsel to the Santa Rosa School Board meeting. He wanted to be with me here today, but he's actually at their meeting this morning. It's just why he could not be here. He also does a lot of speaking on education law topics, especially ESE related. He's handled so many of those types of cases. I really consider him an expert in that. And he's also very passionate about education law, with the majority of his time being spent on education law as well. There's Robert Sniffen, like I said, who founded the firm and has 27 years of experience serving education law clients. We also have Matt Carson at our firm, who was a former general counsel to the Florida Department of Education. So he also is well-versed in education law. And Michael Spellman, who is another partner at the firm, has currently been serving a lot of the needs of the Martin County School Board, including acting as their labor negotiator recently. So there are lots of attorneys at the firm with a lot of experience in education law, including in this Treasure Coast area, who can all help to meet the school board's needs. So I hope that you always feel like if you have difficulty getting a hold of one of us, or somebody's on vacation or sick, that there's always somebody there that can help. You wanted a little brief overview of the understanding of the requirements of your RFP and the methodology for delivering legal services. So I think that I've kind of already explained that we do use a team approach. And I've also mentioned that in addition to all the attorneys who practice primarily in education law and primarily with school boards, there's lots of attorneys that practice in other areas like real estate or labor and employment that we can draw upon too if the district has needs that are a little bit outside of our field. And so it is a team approach, and I think that that benefits everybody. I always have other people at the firm that I can go to that may have more experience than me in something. And the requirements of the RFP were not just for an attorney to service the school board, but also somebody who will interact with the superintendent and staff. So school boards, school districts do this a little differently from school district to school district. Some specifically hire an attorney just for their school board. Some hire one who kind of services both the school board and the superintendent. Some like to separate them. So that's an area where, as I understand it, the attorney who's selected would be representing the school board, would sit at the school board at their meetings, would give counsel to school board members on any types of legal issues, such as public records requests, ethics opinions on things like voting conflicts or gift laws, things that impact school board members. And in addition to that, they would also be helping out with the superintendent and staff with any kind of day-to-day legal questions you may have. And those really run the gamut. It may be a parent custody issue where somebody wants to pick up the student from school that they're not familiar with. It could be an issue where a parent wants to watch a videotape of an incident that happened at school. There's so many different day-to-day legal issues that you run into that, we're just a phone call away and can help resolve any of those types of issues. Additionally, you'll want somebody to review or perhaps draft your legal agreements, also things like policies, also things like resolutions. I know that Indian River County School Board does use Neola as your company that you contract with for your policies. Our firm does serve as counsel to Neola, so we help to draft those policies. And that is something that should not be a conflict of interest in the event that there's ever a need for an agreement between the two parties. Under Florida Bar Ethics, if we were to represent both of you as clients, we would need to get written agreement to do that. If there was ever an actual conflict between you, we would not be representing both parties. But that's something that I think really is a benefit because we do pay close attention every legislative session to the changes in the legislation. We are always reading that legislation and helping to update the policies that many school boards throughout the state use through their contracts with Neola. So being involved in that process, I think, is really helpful because I'm always aware, not just of the legislation, but also of the accompanying policy changes that are required for school districts and paying close attention to that and helping out with that. And this last session was certainly an interesting one. So there was a lot that came out of that one. So that's a bit about what I understand you're requiring for legal services is really you're looking for somebody who can do everything. Obviously, in addition to serving as general counsel, who can answer questions, and that's the area that I really like to focus on because I think communication's important and because I think it really helps to keep districts out of litigation. If things do get into a conflict resolution, our firm does offer all of those types of conflict resolution type services. So that may be more informal, like a Florida Department of Education mediation. It may be a Division of Administrative Hearings, due process. It could be litigation in state or federal court. Our firm has lots of experience in all of those forms. Everybody's licensed to practice in those forms. So that's also something that we have a lot of experience with and can service the school district's needs in that regard. So what I believe you're asking for and what we would be able to provide is a full panoply, you know the word, the full kind of services that the school board and its staff would require. And my hope also, when I say staff, is that principals, it's not just the superintendent or people who are in the administrative offices, that people at the school level, if they're running into something, especially something where, like I said, if a parent's angrily there trying to take a student away and they don't know this parent, and maybe there's some legal agreement that they want help interpreting, or they're getting a subpoena, or this, that, or the other thing, that they would also feel comfortable calling our offices, because that's something also that I really encourage. So that's a bit about the types of legal services that we provide. You wanted to know what I believe is the most pressing legal issue facing school districts throughout the state in the upcoming year. I think it's still the impact of COVID-19. That's something that we've been dealing with, as you know, for a while. That's something that we continue to deal with, and we're continuing to deal with kind of the rolling effects of it. The students who missed school or who maybe weren't as inclined for a virtual environment, who had kind of didn't have the learning gains that we would have wanted. Students with ESE, where we were trying to give them services, but it was maybe more difficult to give them services virtually. So trying to, bridge any of those types of gaps, including not just what is, oh, I apologize. It looks like I've ran out of time, so I will open it up to any questions of the board at this point. Thank you.
So, just so you know, we're going to start with Dr. Schiff and Mrs. Rosario, then Dr. Jones, and Mrs. Berenborg, and I will be last. And we're District 1, 2, 3, 4, 5 as we're lined up. So Dr. Schiff.
Thank you. Thank you. I have follow-up questions on some of the things you said, but I'm going to stick to script for a minute. And I have 4 questions here. I have 10 minutes, so I'm going to invite you to be as succinct and clear and direct as possible, if you would. Hypothetically, the superintendent makes a recommendation to the school board, which results in a division between the school board and the superintendent, and everybody seems to need legal advice. Who do you represent and why?
Thank you, Dr. Schiff. My understanding from this request for proposal is that my primary representation is with the school board, and if there was an issue where the superintendent needed separate legal counsel, that would be my advice, was at that point that I would represent the school board and that it would be the superintendent who would get separate legal counsel. I think on most issues that would not be the case, but there are certainly some issues where that would be the case, even including, let's say, the agreement between the superintendent and the school board for the superintendent's services. That's something where the superintendent may want his own counsel, and I represent the school board.
Thank you. What would your competitors say is your greatest strength and your greatest weakness as a firm and as an individual attorney?
That's an interesting question. And I haven't thought of that one before. I think for greatest strength for the firm would be our good, I think we have great word of mouth. I think that we're well respected. I think that we do have a lot of breadth of experience in education law. I think for myself, something that I've heard people say positively about me, and that is true, is that I am prompt in my communications. So if you give me...
For what? I'm sorry?
I'm very prompt in responding. Something that I've heard is that the number one complaint that clients have with their attorneys is that they don't get back to them promptly enough. And that's something that I'm very conscientious of. So I would say I've heard the opposite, at least for myself, that I am very prompt in responding to emails. Also, I freely give out my cell phone number, so text, cell phone calls. I always am very prompt. I know that some things are kind of an emergency, so I try to really make sure that I'm always checking my messages and getting back to people. And then you also said shortcoming as well. So for the firm, shortcoming, I would say right now we're really trying to branch out and expand. So I don't know if other people would say this, but I would say something that we're trying to do currently is branch out even more. So I don't know if that's a shortcoming, but I would say that's something that the firm is working on, is being able to expand even more in terms of geographically, because like I said, right now their main office is in Tallahassee. It's a little far removed, from some of our clients. And in terms of my own, I cannot say that I have heard of any. Nobody's ever told me any, but if I had to come up with one of my own, I would probably say, just in general, anxiety. I can be a little on the anxious side, so that's just something that I try to manage. I think that's more of a personal management thing than a professional management thing, but that's how I'd answer that. Thank you.
Thank you. So how do you view the school board attorney's role in providing legal advice to individual board members? And how would you handle requests from individual board members?
Thank you. That's a great question. I'm very happy to answer that. I think I kind of went into it a little bit with my last answer, but I happily give out my cell phone number if board members want to give me a call. I think my cell phone or my email is the easiest way to reach me. Some things people may not want to communicate in writing, so I'm always very happy if people want to pick up the phone. You know, I encourage that. You should always be considering public records requests when you put things in writing, even to your school board attorney. Some people think everything's privileged. Really, not all communications with your attorney are privileged. That tends to have more to do with litigation and pending litigation. So like I said, I really try to be very prompt in responding to any of those communications. And as you know, with the Sunshine Law, communications, if I do them by email, you know, I'll probably do them one-on-one or say do not reply all my communications with you about any matter that may come before the board has to be individual communications. So I think that answers your question, but let me know if you have any
I was
follow-up
thinking
there.
more, there are times when a board member's role as a member of the board in needing legal counsel can blur a bit with needing legal counsel on individuals that may come up in their capacity as a board member, but are not necessarily specific to the work of the board. And sometimes those needs and interests can overlap. So I was speaking more to that, and I'm very consciously watching the clock as we go too. So if you want to address that for a minute, terrific. And if not, I'll go on to my next question.
Yeah, absolutely. I hate to speak too much in generalizations. I think something that I feel strongly about as an attorney is I always like to get all of the facts. I think sometimes people think, you know, that you can just kind of make a one-size-fits-all answer when a lot of times things are kind of very circumstantially dependent. So I would say that's something where I would definitely probably want to flesh it out over the phone, make sure I'm getting all of the facts straight. But I would say in terms of things like conflicts of interest or things of that nature, those are the types of things that I advise my clients on regularly. Also, as you know, the Commission on Ethics is a great resource for that, and I actually talk to the attorney at the Commission on Ethics, you know, fairly regularly when I have clients that have questions about any of their kind of professional responsibilities as board members. In terms of other things, you know, I'm happy to advise clients on if they're getting media requests or things of that nature and they want to discuss what they should do. But that I do think is kind of a fact-dependent scenario. I don't know that I have a one-size-fits-all answer for it, other than that I'm, you know, happy to discuss it.
Thank you. Okay, last question. And you alluded to this in your opening statements, probably the wrong term to a lawyer. As a school board, we deal with a wide range of legal issues unique to education, such as IDEA, Section 504, student discipline, FERPA. How would you in your packet, and you mentioned that you have a lot of history with ESE, for example. How do you maintain the balance and represent the district while still actually also supporting parents and families who come to the district with some considerable needs?
Yes, thank you for that question. So something that I think that I've been successful at, I think that your district's been successful at this from when I was speaking with the staff at your district, is with things like ESE, due process requests, if possible, most of those we're able to settle. Most of those were able to settle through informal resolution or settle them before they even get to the due process stage because you know that the parents are getting upset. So whenever possible, I think that that's the preferred method of handling things. Due process can be pretty adversarial, and that's something that I think can be difficult for parents to continue to send their children to school and feel like they're in an adversarial relationship with the service providers. So I think, you know, when it's possible, that the best thing to do is try to work out informal resolutions. One of the reasons that I became a school board attorney is because I really do enjoy doing what's best for school districts and the families and the children. And so that's always something that I'm thinking about in addition to legal interests and risk management, I'm thinking about what is best for the members of the community, not just the client, but also the parents, because I do think that oftentimes what's best for the parents, hopefully, is what's best for the school district. So that's something that I am always mindful of, is trying to maintain those relationships and keep the child at the center of discussions, what's best for the child's education, because that's ultimately what we're here for at the end of the day.
Thank you.
Thank you.
I want to do one quick, you mentioned that there are a number of people in your firm who represent districts. I take it from your application and your statement that you would be the primary person working with this board. Is that true, or would there be some rotation?
Thank you. I live in St. Lucie, so I would be attending your board meetings, but like I said, we really take a team approach, and I would be sharing contact information of several attorneys so that if you ever had questions and I wasn't available, that they would also be there to meet the needs of the Indian River County School Board. Thank you.
Perfect. Mrs. Rosario.
Hi, thank you so much for being here. Thank you for your interest in Indian River. I appreciated the comment that you mentioned about that you love the Treasure Coast. So that means a lot. I do have a few questions here as follow-up to one of Dr. Schiff's questions. You mentioned that it's very important to you to keep kids first. What makes school law practice so satisfying for you, and why?
Thank you. I feel like this question is very near and dear to my heart because I majored in political science before going to law school, and I've spent my entire career serving local governments. It's not the highest paying area of law, but I always knew that, that I was interested, I'm sure like all of you as officials, as politicians, in politics as a way of serving communities. And so I really see what I do from the legal side also as trying to serve the public interests of my community. And it's just really fulfilling because when I work with education institutions, I have worked with lots of other local governments. I really kind of like working with the education institutions the best. I do think that it is really rewarding to work with the board members and the staff because you can see really the impact that you have on the community, and it's really fulfilling to be able to see that in a day-to-day way and to try really to focus on, like I said, kind of meeting the needs of the children and the families, and I see that when I work with education clients. When it gets litigious, it's unfortunate, but most people really try their best to do the right thing legally, as well as to do the right thing by children and families. Sometimes you can't help it, right? Sometimes a family just has an idea and it's not what the law says and it's not, fair for us to do it. And so things may get to that point. But I really have enjoyed working with education institutions over the years because I do meet such wonderful people. As far as I know, the people that I meet, everybody gets into it, for the reason that they care about the community and families and education. And those are their primary reasons for getting involved. And so it's nice working with people who are all on the same page when you work with them in that regard.
Thank you. Thank you for that. The firm seems to have extensive experience working with school districts. You wrote in your packet that was provided for us that you are currently the counsel for Hendry County and now, of course, St. Lucie County. What other school districts have you had experience with? And if you can explain what your role was in with those experiences.
Yeah, absolutely. Thank you, Ms. Rosario. I worked for 10 years, like I said, for Dan Harrell at the start of my career, and he was general counsel for the St. Lucie County School Board. And so at that time, I was doing a lot of the general counsel work for the St. Lucie County School Board. And after that, I did work for the Martin County School Board as general counsel for a while. And right now, they are using our firm for a lot of their services as well, with Michael Spellman being kind of a main person. I know he's been doing all of their labor negotiations. And I have worked more on cases for other districts, as well as, like I mentioned, we use a team approach. So Terry Harmon is the Santa Rosa School Board attorney, but he's often asking me, you know, oh, I'm busy, can you fill in? So I will handle their matters, you know, whatever they are as well. And just working on cases for different school districts. Like I said, I did 2 due process hearings for your school district this year. I did one for Okeechobee County School Board last year. That was a DOA hearing that was in the employment law arena. St. Lucie, I was working on a DOA hearing for them a couple of years ago. That was with a charter school matter. So yes, several school districts throughout the state, and we do represent many other school districts throughout the state. So I would say I'm often drawn into just kind of general review of things for different school districts, whether it's, you know, their forms or procedures or contracts or just general education law questions. Probably too many to remember or mention, but lots of them. Yes, thank you.
Okay, thank you. How would you manage a situation in which the board feels strongly about its position, but you believe that the position is not legally supportable?
Thank you, Ms. Rosario. So as your legal counsel, I give counsel, I give advice, but you are the elected officials. So you make the decisions. All I can do is tell you what I think the law supports. So that's what I would tell you. If you disagreed with me, I tell you, you know, you can disagree with me. This is what the potential outcomes are, and just kind of make you aware of what they are, because for some laws, like public records laws, the potential outcomes can be criminal. But all I can do is make you aware of those and just give you the best advice that I can.
Thank you, I appreciate that. How would you manage a divided board?
Thank you, Ms. Rosario. I would say that when I give counsel, you have to be careful about sunshine law. So when I talk to you outside of meetings, it would be one-on-one. I do encourage you to come to me before meetings if you want to know about the legality of something, because I think that that's just easier to do than at a public forum to discuss. It gives me more time to prepare. It gives you more time to prepare. It's not public to flesh out any kind of things that you have questions on. You know, divided boards, you are all elected officials, and you all know who you represent, and you all know, you know, why you're here. And so sometimes split votes happen. I'm not going to give you advice on what your opinion should be other than legal counsel as to what the law says. Maybe I'll give you best practices or, you know, something like that, but.
Thank you, I appreciate
Thank
that. I think you touched a little bit on this next question that I have, but I'd like if you can expand a little bit more on it. How are you going to be able to handle 3 districts, timing-wise, maybe scheduling-wise, you know, being able to remember all of the policies or all of the, I suppose, the things that we talk about in our board meetings, and trying to stay on top of all of the multitasking. With 3 districts, do you find that you might lean more towards your colleagues to be present, or will you, for the most part, be our general counsel and you expect to be here and fulfill that duty?
Thank you, Ms. Rosario. So something that I mentioned to Superintendent Moore and Mr. Carver was that our firm was thinking of withdrawing our bid when we got St. Lucie. You may know that both of those bids came open at the same time, and I am local. And so when we bid on them both, we were thinking, oh, perhaps, you know, we'll just take one of them and then withdraw from the other. And that's what happened is St. Lucie made their decision. And so we were planning on withdrawing. And when I had that conversation with the superintendent and Mr. Carver, they said, well, actually, we may be able to be flexible on the board meeting dates because there was a conflict there. And we wanted somebody to be able to attend board meetings who has the education law experience, but also isn't all the way up in Tallahassee. And so that would be myself. And so in order to be able to accommodate the Indian River School District, what we were talking about was we would only be able to do it if we were able to make sure that the meetings didn't conflict. Hendry County School Board has their meetings on the first and third Tuesday evenings of the month, which does not conflict with St. Lucie, which is second and fourth, although St. Lucie, they are second Tuesday of the month in the evening, and then their other meeting is actually a workshop that's in the morning, so that does not conflict with their schedule. So my understanding is that if we were to be selected by the board, that we would find a time that would not conflict, perhaps that fourth Tuesday of the month for a board meeting, because that's the only way that we would really be able to do it. In terms of outside of board meetings, which would be covered by me. Oh, I'm sorry. Is that time? Do you want me to finish or?
I think that
Go
I
ahead.
think
Sure,
I would
finish
love
your
for you to finish. I hope that board members wouldn't mind, because I think this is very important to fulfilling the role.
Yeah, that outside of the board meetings that would be covered by me, there would be a team approach so that, you know, if I'm ever busy serving other school boards or, you know, sometimes I go on vacation or I'm sick, that there is also plenty of other attorneys that are there and that also know education law as well as I do that can assist the school board's needs. And like I said, we are currently expanding in that area and hiring more attorneys. So thank you.
Thank you. Appreciate it.
Okay, Dr. Jones.
Good morning. Thank you for being here. A school board member approaches you for assistance in obtaining a copy of a student cumulative folder when the board member is not the parent or guardian of the student. How do you respond?
Thank you, Dr. Jones. I would respond that under FERPA, which is the Family Educational Pupil Records Act, that, and also under state statute, which mimics FERPA, that there is not an ability for people outside of parents to see educational records. There are some exceptions to that. One of the exceptions is if you are a staff member with an educational interest. School board members, on some instances, will see student records. The most predominant example would be if there was an expulsion, where the school board acts in making that order of expulsion. They would need to see the relevant information there. But if there was not a matter coming before the school board for which the school board member had a reason to look at those records, I would say that FERPA does not allow it.
Okay,
Thank
thank
you.
you. You've somewhat answered this, but there will be situations where the school board may require other counsel for special issues. What type of management and oversight process will you put in place for these cases?
Yes, thank you very much. So as I understand, you do have insurance counsel who handles things like your slip and falls. And so that's something where I will communicate with those attorneys to make sure that I'm just keeping up to date on how they're handling those matters. If that's what you mean. A lot of the other stuff we'd probably be able to do in-house. If there's something that we're not doing in-house, that is something that I would want to communicate with the attorney to make sure that I have oversight of what's happening in those cases.
Thank you.
Thank you.
As a lifelong educator, I'm always looking to the future. Where do you feel you would take the board attorney position in the next 5 years and provide examples regarding advocacy, district legal services, and training? So what would that look like?
Thank you for that question. I think training is an area that our firm really excels at. I myself have given lots of trainings to school district staffs in various areas, as well as other members of my firm. I'm a firm believer in training. Some legal trainings are required, like, for example, the Title IX training. Staff were required to be trained on that. Even for areas where staff aren't required to be trained, I think it's important. Areas like public records and student records, I think that those are great areas where all staff should understand the legal implications of those. Something that sometimes you'll find a lot of people don't know are, like with public records, you can make a request to anybody. It doesn't have to be to the public records custodian. You can make it to anybody that works at the district, and they should know how to handle those, even if their only information is send them to the records custodian, who will then know how to handle them. And that's another kind of area where when you're doing training, there's the kind of training for people where it's more notice when things are an issue and know who the right person to send it to is, and then the more in-depth training for the people who actually handle those issues. So I do think, there's different levels of training there that are important, but I think that I'm a big believer in trying to do things on the front end, an ounce of prevention being worth a pound of cure, and I think communication's really important. I think updating those trainings often is really important. I think that being on top of your policies and procedures is important. I think that the fact that my firm does act as counsel for Neola, and this was actually something I wanted to answer for Ms. Rosario as well. The fact that the three districts, the two districts that I am general counsel for and this district all use Neola policies, that offers a lot of consistency from district to district and knowing what the policies are and already having familiarity with them. I always still like to check, just because sometimes districts put in their own little things, or just to make sure I'm not an encyclopedia. I don't have everything memorized word by word, but I do have a lot of familiarity with those policies already. And so that's an area where I think that there's a lot of area of overlap between the districts where there's some efficiency already built in, both with representing those districts and with what I already know. And in terms of leading the district, that is something that I am interested in, is having the more districts that I represent and that the firm represents, having a lot of efficiency built in, where we are keeping on top of all of these education law interests, and especially ones in this geographic area for, all of our clients, and having a lot of consistency and knowledge there that can kind of build upon itself.
So could you tell me a specific training you've done with the school board in the last year or two?
Yeah, absolutely. I trained the Hendry County School Board on the Title IX regulations when they updated their policy to comply with the new Title IX regulations, and they're required to have a training. I did that required training for them. They did have the Neola policy. That's something that I also kind of, with the Neola policy, and this is true sometimes with Neola policies, there's things that you kind of have elective options. So there was kind of also making sure, going through the elective options with them on what they wanted their policy to say. So that was one that I did recently.
That's good. And my last question, tell us about a time when your initiative at work caused a change to occur. What was the situation and what was the outcome?
Oh, thank you, Dr. Jones. That's a thinker. My initiative at work caused a change to happen. Interesting. I would say that one thing that has been a change has been working from home. A lot of people went to work from home because of COVID, but that's something that a lot of people have been going back into the office. I haven't been going into the office as much. My office location is West Palm, and honestly, it's a bit of a drive, and it's not even as close to my clients. So a lot of times, because I am driving around to clients in St. Lucie, to clients in Hendry, to clients, like I've said, I've done work for Martin and Okeechobee and Indian River, that it's really kind of a very flexible location for me to service Treasure Coast clients and not have to be in the office. And so that's kind of changed the way communications worked. So we'll set up things like, when you're in the office, you pass by people, you just kind of have those informal conversations where you have to schedule that more. Like, okay, we want to check in every Monday morning at 10 a.m., you know what I mean? And just kind of have a running kind of meeting so that we're making sure that we're checking in with each other. So I do think that there's been a lot of movement in that regard. Fortunately, our firm has already pretty much went totally digital, so that's not an issue.
Right.
Everything's on our server. Moving to communications like Zoom was not an issue. So I think it's actually all been pretty seamless, being able to do things in a more digital and flexible way.
Thank you very much.
Okay, Mrs. Berenborg.
Yes, good afternoon.
Good afternoon.
I did work in St. Lucie and know Dan Harrell. We have never met, have we?
Not that I recall.
Okay, I just wanted to make sure that was on the camera, and we know that because you do not look familiar, other than I have watched one of the St. Lucie School Board meetings very briefly recently, and I did notice your face on there. So congratulations on that.
Thank you.
What process would you use when responding to school board member questions? And by that, I mean, what research would you perform and what steps would you follow?
Thank you very much for your question, Ms. Brandenborg. So it is fact dependent. Even though I know a lot from 15 years of experience and kind of knowing policies, I tend to always double check. I'll tend to always look up the policy just to make sure it says what I think it says. I tend to always look up the statute. Those change a lot as well. The AGOs, the Attorney General opinions, those are an area that I would often look for school board questions because those relate specifically to opinions on Florida statutes that impact public officials and that discuss things like the laws that the public officials have to follow, such as the Sunshine Laws and the Public Records Act laws. I have mentioned in a previous question that I do speak with the attorney for the Commission on Ethics regularly. He's somebody that presents at Florida School Board attorneys meetings. He's given us all his phone number. He's such a friendly guy. So even when I know answers, I often like to bounce them off of people. I'll talk to people in the Florida Department of Education. If I think that that's appropriate, I'll talk to other people in my firm. So I guess in answer to your question, I would say, even though I think I know a lot of things off the top of my head, I do tend to look at all of those sources as well. And even just getting kind of second opinions sometimes, even where I think I know the answer, just to see if somebody has any other good input. I think of myself as always being very open to, learning new things. So I wouldn't say that I'm totally set in my ways. I like a collaborative approach. I like to do my research, and I like to continue learning and refining my processes. Thank you.
Okay, thank you. What would you recommend as an evaluation process for a school board attorney? How should we evaluate you?
Oh, thank you very much, Ms. Brandenborg. I would say for your evaluation, generally speaking, I think with RFPs, they tend to give you like a point system and then kind of say, up to this many points for this category. And so I'm assuming maybe that's how you'll do it. But I would say if I was to retain an attorney, the things that I would look for are obviously their experience. I do think it's important to get somebody with education law experience because I do think that education law, it's got its own code of law. And even if you're familiar with local government law, like I said, I've served lots of other local governments, whether it's, cities or community development districts, what have you. There are some similarities, obviously, things like Public Records Act, but there are so many things that are school board specific that you wouldn't know that you didn't know about. So there really is just a lot of law in the education law arena that isn't just generalized to those more laws that affect other local governments. And so I do think that it's important to get somebody that does have that type of knowledge and experience, especially when they are going to be, servicing the superintendent and the staff. I think that one of the areas that I feel very comfortable with is, in an emergency, when you do have a parent that is trying to pull a student from school or that's, demanding something like recording a meeting or something of that nature, to be able to have somebody that can kind of come up with an answer really quickly, I think is important. Outside of that, I would say you know, when you're looking for somebody for services, the things that I think are important, that I would pride myself on, are communication and promptness in communication, and then just that you feel that the person, you know, that you could work with them, that they're somebody that you feel comfortable working with and trust.
Okay, so let's talk down the road. Let's say that you are chosen as the school board attorney for Indian River. How shall we evaluate you yearly? How shall it be done?
Well, thank you, Ms. Brandenburg. That's a question that I.
Barenborg, just saying. that.
Barenborg.
That's all right. And he keeps giving me a look, so I'm gonna correct that. Go ahead.
Barenberg. No, thank you. So I would say that it would be probably on the same criteria that I just said. If you think that that you feel that you're getting good quality services, then you would want to continue the relationship. You know, it is really up to you. If selected, I'd be serving at your pleasure. The legal agreements that we tend to have tend to be able to be canceled. You know, we're not trying to lock anybody in for, 10 years or anything. So it's something that, we're here to serve you, and you are the client, and you need to be satisfied with the services.
Great, thank you. Those were all my written questions, but I'm going to allow you, since I have 4 minutes time, to finish what you were going to answer at the beginning. So I'm going to go back and read this last question. If you were selected as school board attorney, what were the first items you would recommend for immediate review?
Yes, thank you. So I think that coming in, I would want to talk to the school board members and to the superintendent and see what issues they have, if any, that they would like to be reviewed, and if so, what the time frame is for that in terms of setting up an order of precedence. I wouldn't want to put, my structure on all of you. I'd like to learn more about you and your concerns, and if there's any areas that you're currently working on that you want reviewed. And I would say, in addition to that, policy is something that, as an attorney, I feel is a very legal matter. It's obviously one of the main things that the school board does is set policy. Those are basically having the effect of laws, and so they are very legal documents, and a lot of times, I wouldn't say a lot of times, some districts don't seem to realize the time pressure, so that's something where I try to make sure that I am stressing that you can get these legislative updates, and there's so many changes to the legislation, and there's so many policies coming down the pike, and you may say, we don't want to look at 30 policies in one meeting, and I would agree with you. And there you can set up an order of precedence so that you are making sure that the ones that are required to be passed and that impact things like student safety get passed more immediately, and then the things that maybe are just little small changes can get passed down the line. So making sure that the board, is up to date on all of those legislative changes that really require being passed, and then that we're looking at other policies in a more timely way that maybe need changes, but they're not immediate.
So are you aware of any immediate issues that are pressing on this board?
From what I understand, you are in litigation, I believe, about masks. No?
No.
Okay. I know that you did have a mask
right now.
litigation that was resolved and motion to dismiss, as was a lot of districts, because the mask mandates were perfectly legal. So I thought that I saw that there was a special executive session to cover some sort of litigation. I think I thought of masks because I saw something in the news about it, but I could be wrong because it doesn't look like.
No, we're not involved in the mask.
Okay, it doesn't look like I'm right. Now, I would say something that has been an area that's been kind of being played out in Florida school boards as well as nationally is that there's been a lot of public participation at meetings, particularly on mask issues, also on some other issues. So I know that that's an issue that a lot of school boards are facing, and some of them want to kind of review their policies and procedures in those regards. That's something that's been kind of both a topic for school boards and I think an area where you're really kind of seeing just the everyday tensions, are playing out in schools. So that's an area that I think that a lot of districts want to look at and that may be an area of looking at.
Okay, thank you.
Thank you.
I'm done.
All right, well, thank you. One litigation issue that this district has only been involved with for 53 years is we're a party to a federal court desegregation case. And what experience do you or members of your firm have in this area of the law? And how can you support the school board and the superintendent in this litigation?
Thank you, Mr. Barefoot. I have a lot of experience in this area. This question seems like it could have been written for me. Currently, Hendry County is still under a desegregation order, and they have been under it for 50-some years, and I am handling it. I've been working closely with the Department of Justice, the United States Department of Justice, on resolving it, and we've actually made a lot of progress in this last year. With their case, what they've been doing is they've been requiring us to compile information on what we've been doing and send them reports. And like I said, I've been working closely with them and trying to see, what they would like us to do to move forward with trying to get it resolved once and for all. There were 2 areas that we had outstanding concerns on, and one was on staff, and the other was on student discipline. And so just recently, within the last month, we actually got an order where we have resolved the staffing issue. So now we're down to one last issue, which is on student discipline and making sure that there, is complete no racial disparity at all in student discipline. And we are continuing to send them information to show, what our numbers are and what we're doing. But also, we've worked on a new stipulation with them where we really worked closely with them in kind of updating things like our code of conduct and kind of updating the reports that we're going to send them to really get to the heart of the matter and try to resolve that. So we're hopeful that after another year of reporting, that we may be able to resolve that issue as well and finally be finished with that. I will say I know St. Lucie School Board also was under a desegregation order that was resolved when I worked for them. That was quite a while back, so I don't remember it as well. But yes, I am familiar with that process, and that's something that, I think that it's important for school boards to be resolved after, all of these years.
Yeah, I suspect that in the situation you described, I'm sure there's some overlap in terms of the 4 or 5 categories that, we constantly are reporting on or trying to report on. You said you've been in contact with the Department of Justice. How about interaction with the litigant and their representation, or their lawyers? Have you worked with them and then you go to the Department of Justice? Do you go through the federal court to the department? How did you end up interacting with the Department of Justice on some of the things you just described?
Yes, thank you, Mr. Barefoot. So as we mentioned, the case has been going on for over 50 years, so I'm newer to the case. But it is a federal case, and so I have entered an order of appearance so that I'm now the attorney on it. We do file our updates with the federal court. And so when I speak with the Department of Justice, I'm specifically speaking with an attorney for the Department of Justice. So I've only been interacting with their attorney, and we have come up with legal documents together, such as a stipulated order where we were found to be in compliance on our staffing issues, but where we were also going to put in place like a new reporting schedule for our student discipline issues with the eye to being able to resolve it within the next year. if we're able to successfully meet our goals in that area. And it's something that I've been closely working with the superintendent and staff with, because they are the ones on the ground. So they are very aware of their requirements, and they are very on board with all of it. Obviously, or at least I think it's obvious, this is something that we don't just want to get rid of from the perception of this is a lawsuit that's been going on for 50 years, but also we want to make sure that our practices are equitable. And I know, since I said that I've been involved with the process and I've been looking at the numbers, we have hired a lot more, minority staff, and we are being very conscientious in our disciplinary practices. So I think that we are doing the work that's required to finally bring our desegregation case to a closure.
In this role, have you interacted with the federal court in Miami? Is that basically the venue when you make your report to the court, or is it another court?
It is the federal court. I'm trying to think which one is for Hendry County. I think it's the 11th. I think it's just the 11th Circuit. Thank you.
Okay. Obviously, after 50-some years, you would hope that, your current situation and ours, we can get resolved, but it's obviously been a challenge if it's gone on this long. Next question. School board, like all other public entities, can be subjected to intense public scrutiny for its actions. Are there any incidents or situations or investigations involving you or other members of your firm which we should be aware of?
Thank you, Mr. Barefoot. And just to go back to what you just said, I would like to note that I have been very proactive. I don't want to say that this has gone on for such a long time because they weren't proactive, but I have been taking a very proactive stance of, we really want to work with you, and we really want to know a timeline and what we can do and what goals we have to meet. And I think that they appreciate that, not just, that we're trying to finish it, but that we're really committed to it. So it's not just, we hand in our report and then, it just goes on and on and on. Like, we're really looking to work with them as partners at this point. In terms of anything that you should know, no, there have been no complaints about myself or anybody else at the firm that I'm aware of.
Okay, good.
Thanks.
We've got a couple of minutes left. Is there anything that you would like to respond to any of us or ask any of us? Follow up from your perspective, additional points you would like to make that relate to any of the questions any of the five of us asked?
Thank you so much. There is nothing that I can think of at this time. If we do have additional time, I'm happy to further discuss any of the questions that you have. I think, that I did get through all of the presentation now, so unless there's anything else that you have for me.
Well, everybody probably has I don't know about everybody, but some will have follow-up questions. So why don't we start, go ahead, Dr. Schiff, you.
Yeah, I have it's not quite a follow-up, it's a thought as I listen to you speaking. As I've seen different school boards around the state, the relationship between the board and the attorney varies. Some boards work with attorneys that are more engaged and directive. Some work with attorneys that take a role of sitting back until being asked, or what I would call, it's the wrong word, a more passive approach. Where do you see yourself on that continuum when working with school boards? And I'm not sure if that's clear. If it's not clear, I'll further clarify.
Thank you, Dr. Schiff. No, I believe that that's clear. So I believe that I'm very client-focused. I'm here to serve you, and I think that my direction comes from the board, how active you want me to be. So if you want me to take a back seat, I can do that. If you want me to be more proactive, I can do that. I do like to, like I said, we have our monthly newsletter where we put out law alerts to keep our clients informed on any kind of litigation or, things that are happening in the education law realm. I have been keeping involved in associations like the Florida School Board Attorneys Association, where Florida School Board attorneys throughout the state that represent school districts communicate on the pressing issues, so that even if something is not necessarily brought to my attention by the client, I'm keeping abreast of what's happening and making sure that if there's something that a client needs to do, that they're aware of it. So yes, I would see that as something that I would be doing, if that
How do you
answers your
s-
question.
Can I
Thank you.
follow up, Mr. Burfoot, clarify? How do you see that occurring when we're actually in a public business meeting?
Thank you, Dr. Schiff. So that may be more that I give you all a memorandum of law prior to the meeting. If desired, you know, I can bring legal updates to meetings as well. But I would see a lot of it is probably also stuff that would be going more through staff than the board directly. So if I'm seeing something that I think, you know, staff need to be aware of, then that's something that I'll bring to their attention. So I would say that it would be dependent on the circumstance, how I would bring it to the board, but it may be just through a memorandum to the board that's not at the meeting, or that maybe I am presenting at the meeting for the board's awareness, or that's going through staff themselves, because it's more of a day-to-day operational matter. Thank you.
I could follow up, but I'll stop.
May I?
Sure.
Thank you. I had a follow-up on a question Dr. Jones asked you with regard to school board members requesting assistance in obtaining a copy of a student's cumulative folder. But to follow up with that, there was a mention about a parent's right to the student's folder. So I thought I heard you say that parents do not have the ability to that information. So I just wanted clarification. Maybe I heard wrong. Do parents have the right to access their students' cumulative folder?
Yes, thank you, Ms. Rosario. They do, and thank you for letting me clarify that. I'm not sure if I misspoke or not, but yeah, they absolutely do have the right to look at their own students' folder, as well as some other rights with regard under FERPA to their students' education records.
Okay. Thank you. I do have another follow-up with regard to your role as our attorney and our meetings. Can you explain a little bit or talk a little bit about your role as the parliamentarian and then your knowledge of Robert's Rules of Order?
Yes, absolutely. Thank you, Ms. Rosario. I know that that's something that Neola has in policy. So the school board does follow Robert's Rules of Order. It's a fairly detailed book. Usually with 5-member school boards, they run pretty smoothly. The chair chairs the meetings. Generally, pretty much everything requires a quorum to be present, physically present, requires a vote. You have a motion, you have a second, you have discussion if you want it, you have a vote. Generally, a lot of items may go on the consent agenda, and then they can all be voted on at once. Sometimes a member may want to pull one for discussion. So that's generally, I know you know how the meetings are run, but generally, as the parliamentarian, if there is a question about kind of the Robert's Rules of Order and what needs to be done, I can step in at that point to offer some clarity about what needs to be done. You know, if board members aren't sure if something needs to be voted on or not, or whatever their question is, if something can be brought back, or I'm trying to think of, you know, some things that have come up. I think I've been asked before, you know, do we have to vote on this, or can this be brought back, or things of that nature, and I can let the board know what they need to do procedurally.
Perfect, thank you.
You said in the DSEG order dealing with Henry County that you had a resolution in the staffing issue. Can you just tell me what that resolution was?
Oh, yes. Thank you very much, Dr. Jones. So our resolution was that the federal court did enter an order It was a stipulated order, meaning the parties both agreed to it, and then we asked the court to agree to it. So the Department of Justice and I wrote it together. We asked the court to approve it, and they did approve it. So it's now ordered that that part of the case has been resolved. So now we're just down to the one issue of student discipline, and that was part of the order, that we were going to continue to work on student discipline.
Thank you.
Okay.
Thank you. I had written down parliamentarian too, and the reason why is because sometimes things can get a little heated. And at what point do you feel the parliamentarian should speak up and interject?
Thank you very much, Ms. Berenborg.
You got it.
Yes, okay.
It's a hard one, I know.
It sounds German?
Yeah, certainly.
Yeah, I'm German, well, my last name, maiden name is Rottinghaus, so German family lineage, so I should know how to pronounce those things, although I'm not great with
du Liebe.
languages. So I think that it really maybe depends a bit, if you're talking about, if I could ask for some clarification, are you talking about heated, the audience is getting heated?
No, on the dais,
Okay.
sometimes, we're passionate, and board members, sometimes things get amended several times, and it gets a little confusing, as when you're following Robert's rules, do you vote on the amendment? Which amendment do you vote on first? At what point would you step in if you're not being asked?
Absolutely. So I would say that generally I allow the chair to chair the meetings. And certainly if they ask me for a point, to clarify what's the correct parliamentarian, decision here, do we need to vote on this, don't we, what needs to happen, I would weigh in. I try not to interrupt meetings. Because I think that when you look at the Roberts Rules of Order and you consider what they're there for, they're there to guide the orderly process of meetings. And like I said, I think that meetings with more people tend to need to rely on them for making sure that the process is more on point and the meetings are able to move forward in a way in which people are able to participate. But having said that, if I thought that the members were doing something that was incorrect, that needed to be changed, I would certainly jump in and voice my opinion at that point. If I thought they were just, discussing amongst themselves and wanted more discussion and it wasn't something that was legally incorrect, then I would allow them to continue their discussion. I understand, again, you are the public officials, and these meetings are recorded, and sometimes people want to let their constituents know what their opinion on something is, and that's their forum for doing that.
Thank you.
Thank you.
All right, I don't have any further questions. So we now, we have an opportunity, I guess, for sort of a wrap-up. Mr. Fagan or Dr. Moore, you want to?
Yes, through the chair. This would be a time in which there's any other further discussion. If all questions have been answered and there's no more questions for Molly, then we would excuse her, take a short break for a second while I bring in the other firm.
Thank you, Ms. Shattuck.
Good.
Thank you.
Maybe this would be I'm sorry. Maybe this might be an appropriate time, if not, someone correct me, to discuss other than the Tuesdays. If we were to consider your firm, other than the Tuesday 4th meeting, and if this board were to consider changing our board meetings, what other days of the week would be available? I think we would need to know that ahead of time so that we can start thinking, what our options would be. So what's your schedule other than Tuesdays? Any day?
Thank you, Ms. Rosario. Yeah, I did have a little bit of conversation with the superintendent, Mr. Carver, about that, and I expressed that I don't have any other evening standing meetings, so I could be available for evening meetings at any other day of the week. I think they were thinking maybe Thursdays, so that would be available for me.
Okay.
Thank you.
Thank you, I appreciate that.
Okay.
All right.
So-
Thank you.
Thank you, Molly. The district the board has a lot to consider, but I want to thank you for considering the School District of Indian River County. If selected, you would be joining a group of outstanding board members who are truly passionate about the work that they're doing, and an absolute great number of people to work with and work for. So, good luck.
Thank you very much, Chair, board members, Superintendent. I really appreciate your time this afternoon, and good luck.
Thank you.
Thank you.
So we'll take a 10-minute break, is that okay? Does that work? Yes. All right, why don't we recess for 10 minutes at 1:19?
Be two individuals, a Mr. Scott Cole and a Miss Anastasia, and I cannot pronounce her last name. I'll let her do that at the meet when she comes in. They do have a presentation. I will give each board member a hard copy.
Oh, okay.
I'll make sure everyone has the score sheets, all the questions, everything that you need.
Can you clarify for me, Mr. Fagan, are we handing back to you this
Yes.
whole thing?
Yes, the interview sheets at the back, there is a questionnaire that I want to mention to. At the very back, there is a scoring sheet.
Yep.
You can just fill that out, sign your name, and give it back.
Okay, but you just want the scoring sheet, not all the notes, or you want the notes too?
Notes and everything.
Okay.
Yes, and then while we go to the next agenda item, we will tally. And after the next agenda item is over with, we'll discuss. Right.
But we're going to have discussion before that, correct?
Yes, we'll figure it out. This next one, we'll just use them and say, okay, you'd like to have a moment of reflection and any final discussion, do your thing, and then we'll take it.
Thank you.
Okay, okay.
Yes, sir.
Okay. All right, we'll go.
Doing a great job, Mr. Fagan. Faga, did you not see his last email? He dropped his N recently. He dropped the N in his last name.
Okay. My husband's doing what he needs to do.
Hello.
Hi there.
Is hearing here okay?
Yes, please.
All right. Thank you.
Yeah, you're right, they're a little warm.
Through the board, I'd like to introduce from Gray Robinson, you have Mr. Cole, and as I mentioned, Miss Anastasia, and she will pronounce her last name.
It's Proto-Papadakis.
Now you know why.
It's just a lot of letters. It's pretty phonetic.
I like that.
Do you want to? Do we just hit it and go forward?
Yes.
Okay.
Let's give it a try to make sure she works for you. Yes.
All right. And I also printed out a copy of the presentation so everybody can have it in front of them so you don't have to look behind you. Are you all ready? Okay. My name's Anastasia Proto-Papadakis. I'm a shareholder with the law firm of Gray Robinson in the Miami and Fort Lauderdale offices. And with me, I have my partner, Scott Cole, and he comes to us from the Orlando office, a shareholder there. I'm going to start by giving you a brief overview of our firm. We are a full-service law firm and consulting firm. I believe we are the largest Florida-based law firm, or if not one of the largest Florida-based law firms, with our headquarter office in Orlando, Florida. The firm was established in 1970. It has 14 offices now across the state of Florida, so our firm has offices from the Panhandle all the way down to Key West, and lawyers that practice in almost every single area of practice that you can think of, both on the law side and on the consulting side, 250 lawyers and consultants as well. In the last 50 years, we just actually celebrated our 50-year anniversary. The firm has created an environment that we're able to service our clients on a full-service basis, while also being really involved in the communities in which we serve, and take a lot of pride in being a purely Floridian law firm. I'm going to go through our team that we've put together here. I'll start with myself. I've been practicing municipal law for about 13 years. I started my career out of law school working in a small boutique firm that was municipal-focused defense firm. So all we did was municipal defense, and that was for not only city organizations, but also school boards as well, and police office divisions and sheriff's offices as well, captive counsel for the Florida League of Cities. In my time there, and also in my practice at Gray Robinson, where I continued to practice not only municipal law, but also in the private sector, I have always kept municipal clients, and one of the clients, my largest client, is the School Board of Broward County. And with the School Board of Broward County and other municipal clients as well, I practice in both the state, federal, and appellate courts, as well as administrative matters before DOA and also at the board level, defending negligence claims. I do a lot of employment defense, so claims for negligent hiring, training, retention, and supervision. I do the majority of the district's sexual assault, battery, and rape claims, their employment claims, as well as IDEA claims and claims for denial of FAPE. And I have a specialty in the defense of ADA claims. Also for them, battery claims, as well as sunshine request, public records, and other general tort litigation matter, personal injury defense, and things like that. As part of my work with the School Board of Broward County, I was on the Marjorie Stoneman Douglas defense team, also currently representing the district in a challenge to the new Fairness in Women's Sports Act. In my private practice, I sort of do the same kind of work, but for private clients. So that includes contract work, litigation work for them. I also do personal injury defense for private clients and employment defense claims as well. In addition to myself, we have our co-team lead who could not be here today because she's actually in federal court on a summary judgment hearing. Her name is Stephanie Marchman. She has 15 years of experience representing local governments, and she also served as the assistant city attorney for the city of Gainesville for over a decade. She is based out of our Gainesville office. She handles labor issues, including negotiations and interpretations of CBAs, grievance, arbitrations, and appeals of labor matters for the School Board of Broward County currently. She recently served as a labor and employment counsel to the School Board of Marion County, the Volusia County School Board, Alachua County, the City of Gainesville, the City of McClenny, the City of Miami, the City of Winter Haven, and the Florida Association for Healthy Start Coalitions, Hillsborough County Aviation, and the Village of Biscayne Park. So Ms. Marchman has a lot of experience in municipal matters as well, and a lot of labor experience. Our next team member is Mr. Cole, and since he knows himself best, I'm going to let him give you,
Thank you.
some background, some of his background.
That would actually be my wife who knows me best. But, so I started out in private practice in 1986 for 6 years, and then I joined the University of Florida as an associate general counsel. And then I spent almost 19 years as general counsel of UCF. I've only been with the firm about 6 months. I am chairing their higher education practice. And so while most of my experience has been at this higher education level, obviously there is very, very large overlap between the two practices. So I've spent almost 19 years working with the Board of Trustees. I understand that role extremely well. I understand the challenges you have as board members and so many different levels beyond the legal challenges. And so I try to give the best advice I can in context of the other issues as well that you're dealing with. I am very, very well versed in FERPA and public records law and sunshine law and First Amendment and rulemaking. Not a whole lot of people know about rulemaking. I actually do. And I also student conduct and Title IX. So pretty much all of the educational issues that are faced at all levels of education I've had to deal with. So I'm very excited to be here today. This is an area of the practice that I would like to expand even more into, and I'm hopeful that my experience as a general counsel could be helpful to you.
Thank you. And that is why we added him onto our panel here today, because he does bring a real depth of experience that I think would be very beneficial to this board. We also have on our team Brian Fender. He is our municipal bond guru. He represents a variety of clients that include school boards, universities, aviation authorities, banks, and other direct purchasers of municipal debt, bondholders, charter schools, cities, counties, expressway authorities, government financing pools and programs, special districts, sports authorities, state program, tax-exempt organizations, and other special districts. He is involved in more than 650 public finance transactions and has represented clients in the issuance of more than $40 billion of tax-exempt and taxable debt. So To the extent that there are any bond issues with the district here, we have a professional that has a lot of experience and we can dedicate to those issues. We also have Greg Herring. Mr. Herring is board certified in labor and employment law, and he's also board certified in education law. He focuses his practice on management, labor and employment law, and he represents local and national management clients, including several county school boards in a variety of matters before not only the state and federal courts, but also in administrative proceedings as well. We have Heather Ramos as part of our team. She focuses her practice on all aspects of state and local government law. She has a practice area that includes land use, as well as Florida public records and open meetings law, ethics and gifts law, sunshine, public records, taxation, finance, and utility. She serves as special counsel to public universities, hospitals, and hospital districts regarding some of these practice areas, including the sunshine law, ethics, gift law, financing, and public records. And she also assists in the establishment of community redevelopment agencies and other local government financing mechanisms. And finally, we have Rebecca Rodriguez. She is a litigation-focused professional with our Fort Lauderdale office, focusing on state and federal litigation, appeals and general compliance matters for corporate clients, financial institutions, and government entities. She serves as special counsel to the Emerald Coast Utilities Authority, and in the past has served as general counsel to various municipalities. She also has a specialty in public records and sunshine law particularly. And so as part of the RFP, we were asked to discuss what our service methodology would be. As we've gone through the team, you can see that we currently represent school districts throughout the state, and we are familiar with issues that the school districts face and how to successfully navigate them. Of course, we would always tailor our service to what the needs of the district are and how you all would like us to provide services, but our initial proposal is that we would have a dedicated individual, which would be Mr. Cole, sitting on your dais to act as the general counsel and be the sort of the face person for our firm in terms of how the services will be provided on a day-to-day basis. He would be providing general counsel services to you through your board meetings. And I'm not sure if you have counsel attend workshops, but if you do, he would also be counsel that would attend workshops. We would also be willing to provide either on the board day or on a separate day, if that's what serves your needs best, an office hours day where Mr. Cole can actually be here at the district to interface with your various departments and answer, any day-to-day legal questions or issues that come up. And then our team would be sort of back of house support for Mr. Cole. The nice thing about having a firm like Gray Robinson is that we have such a breadth of knowledge in not only every area of the law, but throughout the state of Florida, whether it is a lobbying need that you have, if it's a litigation need that you have, if there's an administrative need, or whatever the district can possibly face, from financing to litigation to just general advice. There is a professional like Gray Robinson in-house that can provide that expertise to you. So we would not need to go outside of our firm to find a professional for you. All of those services can be provided to you through Gray Robinson, and it would not require that the district has to navigate our firm. You would have one dedicated person to whom you'd make those requests, and to whom that would be your primary point of contact. And we back of house would support that the team that needs to be in place to address those needs. If there, well, I guess I'll leave that to the question part.
Okay, so you had specifically asked two questions. One was the most pressing legal issues. To me, it's the current activism in public education right now is a huge issue. That is a real mixture of First Amendment rights, sunshine law, public safety. To me, some public safety issues, when in doubt, always come first. People need to feel safe when they're at public meetings, and so there are ways that you can run public meetings to still give the public access, but also maximize the safety of all the participants in those meetings. So to me, that's a very large issue. And of course, a lot of this activism is leading to lawsuits across the state, challenging, open meeting laws and public records law, bringing First Amendment claims, attempting to regulate curriculum. All of those things are key issues that our firm is very well qualified to deal with. Other issues, you have unionized employees. I'm familiar with dealing with that. It's an important issue. I think a lot of those issues become really important when you're in a situation when you're having to respond quickly to challenges and you've got collective bargaining agreements that may limit how quickly you can respond to issues. So that's certainly an issue. First Amendment free speech, not only for your employees, but your students in and outside the classroom, especially with online postings, and where is that nexus between the school and their private role as a child. So those are interesting issues that are working their way through the courts now. Student discipline, always a challenge. Title IX, putting specific with the newer regulations and upcoming changes to Title IX, everyone's going to have to reconsider their policies and procedures on that. Changing state and federal regulations. K-12 is as you know, a highly regulated activity, and so it's so important to stay up to speed on all of the regulations and be able to respond to those changes quickly. And of course, FERPA is an issue we all have to deal with every day at every level. And so you asked also what we would propose in terms of day one. First is conduct a risk assessment for the school district, review your policies, your training programs on Title IX, public records, sunshine law, student discipline. Look at your current litigation. What are the activities that are leading to that litigation, and what are some proactive steps you can take to try to minimize the amount of litigation that you're in. Litigation is expensive, it's time consuming, and it distracts people from doing the important business of the district. So you obviously want to reduce that litigation as much as possible. And I'm down to 20 seconds, so we'll stop right there.
Oh, I didn't even notice the clock there. So, yeah.
Like I said, I've worked with boards before, so I know about the board.
That's the end of our formal presentation, but we're certainly open to open dialogue on any questions that we can answer for you. And I think we also have a few that we have.
So we're going to start from your left to right,
Okay.
and Dr. Schiff will lead it off.
Hi.
Good afternoon, thanks for being here.
Absolutely.
It's funny, I listened to your presentation, and we have a list of questions that we're all asking, but then I listened to the presentation, and of course, I want to ask completely different questions. So hopefully we'll have a little time for that. I'm also going to say that I have only 10 minutes for this, so I'm going to invite you to be as succinct and direct as possible, if you would, in your answers.
Sure.
So hypothetically, the superintendent makes a recommendation to the school board, which results in a division between the school board and the superintendent. Everyone seems to need legal advice. Who do you represent in this situation, and why?
So the attorney represents the school district board. The board is the governing body of the district. The board is responsible for overseeing the activities of the superintendent, and in those hopefully unlikely situations where there's a diversion of interest, the legal obligation goes to the institution, which is represented by the board.
Goes to the institution as in the board, not in the institution as in its CEO, the superintendent.
That's correct, is the board.
Thank you.
Yep.
What would your competitors say is the greatest strength and weakness of your firm?
Well, I think that the greatest strength of our firm is that we have such a statewide presence and such a breadth of knowledge in so many different practice areas. That's the benefit of having a firm like Gray Robinson on your side, is that it's literally a one-stop shop. Anything that you would need from a legal or lobbying perspective, I believe Gray Robinson can serve you for. And I think the second part of your question was, what would your competitors say is the greatest weakness?
Weakness.
I don't see any weaknesses in being able to provide that kind of service to a client, but maybe smaller firms would say that, you're not going to get the attention that you deserve because we have a larger firm. I don't believe that to be true. I've been serving the school board of Broward County for about 10 years. I am in constant daily contact with my general counsel there and the general counsel's office. I answer their calls and their emails. Whenever they call me and email me, there's never a time lapse. There's always an open dialogue. And so I think that the nice thing about Gray Robinson is that the practitioners within the firm have the ability to run their practice the way that they want to. And so it's up to the individual lawyer to, run their practice that way. And that's the way that I run my practice. I'm very responsive to my clients and to my clients' needs because that's what they're hiring me for. They're hiring me to be there for them, and that's my job.
Thank you. How do you view the school board attorney's role in providing legal advice to individual board members? And how do you handle requests from individual board members? I'm going to clarify in that sometimes there might be a gray area between what is representation as a school board member and what are things that come up in the context of being a school board member, but might not necessarily be as part of their school board member role. If you could address all of that.
So the general counsel represents the board as a body, and the board acts through majority vote of the body. And so no one person is the client. The board as the collective body is the client. So it's really, it's a preference of the board on how they would like their general counsel to interact with each of the individual board members. And so long as the attorney is not asked to do anything that would be inconsistent with the obligations to the body as a whole, then there's no problem with consulting with individual board members. That's not a problem at all. At UCF, for example, we regularly had one-on-one meetings with our individual trustees to talk about sensitive issues that could not be discussed necessarily in public. You're not allowed to carry messages back and forth between, individual board members. That's the way it works under the Sunshine Law. But you certainly can get a sense of the leanings and maybe a little more thorough sense of where the individual boards are, and that helps the general counsel give better legal advice.
Thank you. I've been a professor at FAU for nearly 30 years, so have a sensitivity to higher education as well.
We'll say hi to David Keon, one of my closest friends.
Okay, we're not tight, but I'll look him up.
Okay, he's awesome. Yeah.
I mean, I don't know.
Okay.
As a school board, we deal with a wide range of legal issues unique to education law, such as IDEA, Title IX, Section 504, discipline, FERPA. How would you represent the district and still support parents and families who are coming to the district because of a particular need?
We did that one? Yeah. Okay. Well, obviously, you're here to serve the community. You're here to serve the parents. And so, the idea is that we can find a way to do both. And that's one of the jobs of the general counsel, is to find ways to accomplish the things that you want to accomplish. The role of general counsel is not to say no. And so finding solutions that work with the legal constraints on the board, but also accomplish the needs of your community, your constituents, the parents, that's the win-win. So that's what we try to do as much as we can, subject to whatever legal constraints that you may have as a board.
And then there's 4 minutes left. So if I may, I'm going to use some of that. Sure. Can you speak a little bit about who is present at our school, who is going to be at our school board meetings or our workshops, or what, is it both of you, is it one of you, is it somebody else? Can you speak about that a bit?
Sure. So the proposal currently is that Mr. Cole will be the face person. So he will be the person that is going to be present, sitting in your dais for your board meetings, and to the extent that you have counsel at workshop, which I'm assuming that you do, he would also be there. If there was ever a conflict and he couldn't make it, of course, there would be someone else that would show up. That would either be myself or Ms. Marchman. And then we would support Mr. Cole in any of the needs that he has to serve the board back of house with our team that we have in place.
And can you remind me, are you located in Orlando?
Orlando.
So you would come back and forth?
Yes.
To us. And forgive me for asking this, I don't remember in your proposal, do you charge for travel time as well?
Yes.
Okay, thank you.
No?
I'm going to cede my time for the moment and hold it for later.
Ms. Rosario, you're up.
Hi, thank you very much. Thank you for being here, and thank you for your interest in our school district. So I will begin with, I know that you have had higher education experience, but how many other school districts have you and/or the firm had experience, direct experience representing? And if you can talk a little bit about that experience.
So I don't have the list of all 250 lawyers, but I know that we have represented, I currently represent the School Board of Broward County. I represent them in, Ms. Marchman does all of their labor and employment work, so they don't have an in-house person that does that. Our firm does that for them, and that's negotiating their CBAs for them. Any administrative issues that come up, we do their grievance, their step grievance issues with them, as well as the hearings. All labor and employment issues are handled by Ms. Marchman. I do all of their litigation, not only, and their litigation is split sort of in two pieces. There are parts that come directly from the general counsel's office, so those are claims that are not covered by their third-party administrator, and then also serve as cadre counsel to their TPA. So doing the majority of the work that I do for the district is employment litigation, their IDEA work, a lot of claims for sexual assault, battery, rape, abuse of the ASD or ESC population, and their employment work. In the litigation context, I also do some of their sunshine work for them as well. So depending on whether it comes, from the work that comes in from the districts directly versus their TPA, there's some differences in the kinds of cases that I do, but Ms. Marchman and I work together on that as a team. I know that Ms. Marchman is working, I believe, currently in the employment litigation for Marion County School District. I'm also doing some cases for Marion County School District in the personal injury defense realm. And I believe that our firm also represents Orange County School District currently, sort of same capacity that I'm doing for the School Board of Broward County, but it's another individual that's not on our team here.
Thank you. What makes school law practice satisfying to you?
So I've spent my all but 6 years of my very long career in education. I'm a true believer in education and the power that it has over people's lives and their ability to get ahead. So that's what gets me going. It's about the students. It's about the stories of the people who look like they don't have a chance, and boy, they find a way through education to achieve their goals. So, it's personal for me. That's why I've dedicated my career to it. It's life-changing, and it's not without its challenges, but the benefits so outweigh the challenges we all have to face along the way.
So how do you see yourself transitioning from that area? I don't know if you're going to leave that area, or add on to a local school district. To the experience that you have had. How do you see that transition?
Yeah, I would like to add this to the overall education practice. I've only been in the firm about 8 months, so this would be my first school district full-time work. But it's such an important area. There's a natural affinity. I've worked with school districts a lot between the University of Florida and UCF, between our colleges of education and nursing and all the overlap we have with them. So I have worked with the district schools across the state of Florida. But this is a natural extension of what I'm doing, and I just think especially now it's a really, really important area in Florida right now.
Isn't that true? It's definitely an interesting time.
Yes, it's a very interesting time.
How would you manage a situation in which the board feels strongly about its position, but you believe, as general counsel, that the position is not legally supportable?
So my role as general counsel is to give the board the best advice that I can. The general counsel is not the decision maker. Now, if something is truly illegal, if it's something somebody's going to go to jail, then obviously that's a different situation, and that's when you have to say, no, that this cannot be done. In 30 years of practice, I've never actually had that come up. So my job is to advise on the law, and if there's a strong, desire to accomplish a certain purpose, then it's my job to find the legal way to accomplish the purpose. That's my role. So it should never be, there are very few things in my experience that would ever lead you to have to do anything that's illegal to accomplish your purposes. There will be a legal way. It may not be perfect, but there will be a way to do it, and we want to make sure everybody stays out of jail. That's, priority number one.
That would be important, right?
That would be very important. That would be a failure on the general counsel's part.
How would you manage a divided board?
Oh, I've done it for a very long time, because board members are people like everybody else. Part of the role of a general counsel is also to be sort of a counselor and working with people and trying to find common ground on issues as a neutral third party. The general counsel doesn't represent a constituency. The general counsel is there to represent the board as a whole and try to find solutions to problems. And so, people can differ on things, and they're all not necessarily wrong. They just believe different things, and that's fine. So my job is to work as hard as I can to find consensus among the board and a path forward that's legal.
Thank you. Can you explain, can you think of an experience in which that has happened that you're free to share, and how you were involved in, your word was counseling and providing solutions to those problems?
Sure. So in the past, we had some board members who wanted to abolish tenure at the university, and they felt very, very strongly about that. Most of that feeling in these particular cases, I know everybody's different, were based on misunderstandings about the nature of tenure, what it was and what it wasn't. And I worked individually with those two particular board members and explained what tenure was, and that it's not a guarantee of employment for life, and spent a lot of time going through that. And I was able to actually turn them around to realize that probably was not the best thing to do, and we resolved the issue. So, sometimes it's just a matter of having misinformation, or that if you take the time, first listen to your client, listen to your board member and what their concerns are, and not prejudge the situation. And then once you figure out what the issues are, try to find some, like I said, some common ground.
Okay, thank you. We have some time, so I do have another question that I want to ask. With regard to parental rights, being a post-secondary education, or having that experience in post-secondary education, I imagine that parental rights is not usually a concern, because of course you have children who are no longer children, they're 18 and over adults. How would you transition the experience handling a concern with regard to parental rights from the post-secondary educational experience to a local school district where everybody is under 18 for the most part?
Right. About the only place that we would deal with that directly at the post-secondary level is FERPA, when we have a student who's a dependent of their parents and they still have their FERPA rights. So obviously it's different in K-12 education. So parental rights are relatively well-defined, either by statute or by case law. And so the first thing is to feel comfortable that you're on solid ground and understanding exactly what parental rights are. And then making decisions, obviously to the extent that you can tailor your decisions to not trample on those parental rights, you try to do that. Of course, there's also a lot of misunderstanding about parental rights, and I know it's not always popular, but they are not unlimited. We know that. We know that you can't abuse a child, you can't refuse to educate your child. There are limitations on parental rights. That being said, so much of this is not a legal issue. It's an emotional issue, and it's something that I'm sure you deal with all the time. And so I think the first approach is to try to find a way to address what's really going on with a parent first in terms of their particular circumstance. And if that's not successful, then you may have to make decisions that are not popular with some parents. I'm sure with others they are. But you want to make sure when you do that, that those decisions are legally grounded.
Thank you, I appreciate it. And I think with that, I will end my questions.
Dr. Jones, you're up.
Thank you. You've been at UCF about 18 years. What happened to us last week against SMU?
Too many injuries.
Yeah.
Too many injuries. The Gus bus has lost all 4 wheels, and gosh, I don't know.
It's interesting. There's a reason for this. All 3 of my students went there for their undergrad, and then they went to Florida for the graduate. But the question Ms. Rosario asked was interesting because I had an issue at UCF as a parent. I'll share that with you someday.
Sure.
It was good. It was good.
It was a good experience?
Pardon me?
Was the experience?
It was really good. Yeah,
good.
it was really good.
Okay.
It was really good.
We were probably involved in that one then.
Well,
was all Mr.
long story
Cole.
short, my son was in a very major accident,
Oh,
and
sorry.
they needed a note from the surgeon saying he wouldn't be in class. And what I did for parents on their website at the time, so that parents knew what to do in these cases instead of being dropped from classes, it turned out well.
Good.
We met with department chair and everything.
Wonderful.
A school board member approaches you for assistance in obtaining a copy of a student cumulative folder when the board member is not the parent or guardian of the student. How do you respond?
So the board member's asking for a copy of a student's records. Well, there has to, with everybody, whether it's a teacher or a school board member, there has to be a legitimate educational purpose under FERPA in order to review those files. So that's got to be the first question. If there is one, no problem. If there's just kind of interested, that's not going to legally be
Thank
okay.
you. There will be situations where the school board may require other counsel for special issues. What type of management and oversight process will you put in place for these cases? I think you've kind of answered that, but a little bit more on that?
Sure. So that's one of the real benefits of having a firm with the level of expertise and on so many issues is that we're all partners. We work together. We have the best control you could possibly have over other counsel is that they're in your firm and you can make sure you can really stay on top of what's happening.
Okay. Where do you feel you would take the board attorney position in the next 5 years? Provide examples regarding advocacy, district legal services, and training. I'm always looking ahead as an
Yeah.
educator.
Yeah.
Can you give me some examples?
So I'm a big believer in avoiding legal issues if you can, especially litigation, and that comes to being very proactive in making sure that your policies and your practices and your procedures are all up to date and that they're being followed. And even sometimes if a procedure isn't followed, if it's in place and people are acting in good faith, you still tend to be pretty good in litigation. So first is focus on proactive law
Okay.
and proactive risk management. That's the first thing. Second of all is to develop a culture where the general counsel is seen as an accessible person to decision makers within the school district so that they feel very comfortable coming in and asking questions. I'm a big proponent of being accessible because you can avoid so many legal problems by having people come to you early and say, hey, I'm thinking about this instead of I've done this. And if you can get them to the first part, you can solve so many issues early and save a lot of money and a lot of grief.
Okay, thank you. Tell us about a time when your initiative at work caused a change to occur. What was the situation and what was the outcome?
Wow, okay, I got to think back on that
I
one.
know.
So one of the things that I'm very proud of doing at UCF was we were one of the first universities to hire a full-time university-wide compliance officer. And that was not the most popular thing to do, but what I was seeing was a lot of issues in the risk management area, unnecessary legal issues occurring because of a lack of true enterprise risk management. And so I worked for 2 years with my president and my board to make it happen. It's now been 10 years, and I will tell you, they would never consider not having a compliance officer now, having had the experience and the savings they've recognized because of that. So that's one area where it was really not even a legal issue, but I was able to, I think, really benefit the university.
I'll go ahead and go to the next one. I'll bring up something at the end.
Oh, me? Okay.
Sorry.
Thank you for coming today, Mr. Cole and Ms.
Anastasia's fine.
Prapo Papadakis.
Close.
All right.
Yeah.
Well, my last name gets confused a lot too, so I can understand. Thank you for being here. When we saw your proposal, when I read the proposal, I thought you were going to be the school board attorney. So thank you for clearing that up because that's what the proposal looked like. So I understand that you would be the proposed school board attorney. Great, so this question is for you then. All right. What process would you use when responding to school board member questions? And by that, I mean, what research would you perform and what steps would you follow?
Well, so first thing is to have it's up to the board member how they prefer to communicate. I like phone calls personally, because they don't create public records, and sometimes when thoughts aren't totally formed in your mind, it's better just to have a conversation on the phone. So first is to have a conversation about what the issue is. If it's something that I've dealt with before, if somebody's got a FERPA issue or public records thing, I mean, I can answer those like that. If it's something that's a little more involved, then I would say, okay, I'd ask a few questions after I understand what the issue is, and then I would go look it up, see what the law is on that issue, see if there's any other non-legal considerations that may be flowing around the legal issue, and then get back to that board member and respond.
Okay, thank you. What would you recommend as an evaluation process for the school board attorney?
Well, the attorney ought to be evaluated by the board every year based upon their performance, whether that's some people do a self-assessment by the attorney, and then there's a response to that from the board, or the board may just want to do have its own particular evaluation tool. I think all of those work well as long as it's a thorough evaluation, because it's not only an opportunity for the board to express its feelings about how well the general counsel is performing. It's an opportunity for the general counsel to realize where he or she needs to improve their performance. So it's a very valuable tool when it's done correctly, and I'm open to any sort of review like that.
All right, thank you. So I asked this before, so I'm going to ask it again. What recent issues do you know of affecting the school district of Indian River County?
Well, I know you've had several issues with some school board meetings, which...
No, ours run all smoothly. very
Yeah,
short.
yeah, and I understand you've also had some litigation arising out of some of those. I don't know all the details of them. I know that you're not alone in dealing with those issues, and so they're difficult. I don't know all of your particular individuals involved, but I know you've had some issues at your school board meetings.
Okay, and question for you, because this would be your first school board attorney at K through 12.
Yeah.
How versed are you in Robert's rules? Do you use them in your meetings?
All the time.
Okay, and as parliamentarian, which we use our school board attorney as parliamentarian, and
Yeah.
yes, she does attend our workshop, she's right there. So, as parliamentarian, at what point would you step in instead of being asked?
Well, if you're about to go down the road of not doing something the right way, I'd go ahead and step in. I do it in a very nice way by saying, excuse me, Mr. Chairman, you might want to, you haven't gotten a second on this motion, or you may need to get a 2/3 vote on this. So yes, I'd go ahead and assert myself in a positive way, because what you don't want to do is have to repeat the action because it wasn't done in accordance with your own rules.
So you said you did use Robert's rules then?
Oh, yes. Yeah, it's not something you advertise as a skill. People think you're a little nerdy, but I actually do.
It's okay to be nerdy as an attorney.
Okay, good. Yeah, so yes, we used that the entire time I was at UCF.
Okay, thank you.
Yep.
I'm done.
You're all set?
5 minutes and 45
We're
seconds.
zipping right along here.
There you go.
This is impressive. Well, again, thank you both for coming. First question for me is, our school board is a party to a federal court desegregation case. And what experience do you or members of your firm have in this area of the law? And how can you support the school board and superintendent in this litigation?
Do you want to?
Well, you said it's a desegregation matter? in
We have
federal-
been under a desegregation order for 53 years.
Okay.
And we are under the, correct me if I'm wrong, in effect, the oversight of the federal court in Miami. And the litigant is the NAACP, the local NAACP. And so it's something that everybody after 53 years, you would like to get resolved. So what kind of experience do you or your firm have?
So my practice, I would say, is 50% or more federal litigation, because I do a lot of the IDEA work as well as employment work, which inevitably is, federal claims, Title VII, things like that. So very comfortable in federal court. Our team is very comfortable in federal court. We have a lot of litigation experience. And so I'm not sure if your claim is a covered claim through your TPA such that you have cadre counsel, and is your question that how would the general counsel assist the defending counsel, or would we be stepping in as defending counsel on that matter?
You would represent the school board.
Okay, so we would be defense counsel
Right.
on that matter. I think, again, federal experience, litigation experience, I've been doing federal work the entire time that I've been a lawyer. Since the day I got out of law school, I've been doing federal work, so I'm very comfortable in federal court in litigation matters. And I view my role as providing zealous advocacy for the district, because that's my client, but also providing, honest assessment and advice on what our strategies are, what the likelihood of success is on the strategy, but ultimately letting the client pick the course of action, because you're the client and it's your decision. Our job is to provide you with the legal basis for what we want to do in a strategy recommendation and the pros and cons of the available options for you, and then to defend the position that the board wants to take.
So, following along in that discussion, there are 4 or 5 areas that you try and get agreement with from the litigant. It can be everything from the staffing, and does it represent the community that we serve? It can be student discipline. Is there a disproportionate or perceived to be a disproportionate discipline problem for one demographic versus another? It can be the academic achievement of one demographic is lagging behind other demographics, those kinds of things. So it's not just being able to represent us in court, but also working with the superintendent, his team, and the board in how to present data, information in a manner that will favorably be viewed by the court and, or in this case, the litigant.
Right. Do you have?
Yeah, so I agree. I think you have to have your ducks in a row and try to the best of your ability, address all of the issues that were raised that resulted in the desegregation order. And when you feel like you're in a position to do that, then you go back. I mean, there have been multiple desegregation orders that have been lifted around the country when the district is able to show that the issues that were presented 53 years ago no longer exist or are not significant. I also think that your success often depends upon what the nature of the courts are at the time that you go back in for a consideration of these issues. In general, the courts now, there has been a move toward a little more conservative court than existed 50 years ago. So I think the timing may be right for reconsideration of those issues. But you'd have to look back. I mean, the strategy was you go back and you look at the order, exactly what the issues were that led to the order. Then you pull all the data together to see exactly where you stand in comparison to where you were before. And if you feel like you've met most of that, then go for it. Try to negotiate a resolution with the plaintiffs and see if you can go to the court together and get a agreed upon order lifting the segregation.
I have one more question, but I might, while we're on the topic, for any of the other board members, because this is something after 53 years, I think this superintendent and this board would like to be part of the solution, and if there's a way, so if there's any other follow-up questions to this specific thing that anyone would like to ask?
I have
Yeah.
one. Do you specifically, your firm, have experience with desegregation orders?
I've never litigated a desegregation order, but I can't speak for the 250 professionals that we have. I'm confident that they have. I just don't know off the top of my head if they have, but we
Okay.
can certainly research that for you and get back to the board through Mr. Carver and let you know our specific experience on that issue and pull those team members in if required.
Right, it's a hard question to ask, I guess, on the spot, so thank you for that.
Of course.
Dr. Schiff, yeah, go
Yeah,
ahead.
I actually want to follow up on that. One of the things, and then when we get to it, I have another follow-up question. One of the things that you mentioned as an advantage of your firm is that you have so much talent in one place, is your size as an asset here. if there were somebody who you discovered had experience in desegregation orders, federal desegregation, or any form in a school district, is that the person who would serve us in this particular instance, or would it be you as our primary counsel, and would that person come along with the hiring of you as your firm, or is that a separate contract we would do with them for that particular issue?
So you're hiring Gray Robinson as the firm. Mr. Cole's going to sit as your contact person, but you're getting the experience, the breadth of knowledge of all of our professionals. So if we were to look back and see that we have someone that specializes, and I'm confident that we do, I think Mr. Herring does, but I don't want to speak on that without getting confirmation from him. But yes, you would have the experience of that individual as well. We would bring them on as needed on a case-by-case basis, for example, for this issue, and have them assist us. So to the extent that it is a litigation that they need to defend the district on and appear as counsel, we can have them do that. If it's more of an administrative issue that they can counsel with Mr. Cole on, and then Mr. Cole can present to the district whatever recommendations or processes that we need to put in place, that can also, that's an arrangement that we can also set up, but it wouldn't be a separate retention of that individual. You're hiring the firm.
Okay, do you have another question, Dr. Schiff?
I have follow-up questions, but I'm not sure if we're up to that yet, because
All
I don't know.
right, so
if we're
let me
done.
ask one more question, and then we can do the follow-up unrelated to the desegregation case. The school board, like all other public entities, can be subjected to intense public scrutiny for its actions. Are there any incidents or situations or investigations involving you or other members of your firm which the school board should be made aware of?
None that I'm aware
No.
of. No.
Okay. All right, follow-up questions. Dr. Schiff, go
Answer
ahead.
that? Yeah. One of the things that comes up about your firm, that you are selling as an asset, but I also see as a possible, as something I'd be concerned about, is you are really big. You do a lot of work in Florida. All of that was in your presentation. How do I know, as a school board member in Indian River County, that I am going to get the personalized service that I need here as an individual board member, as corporate board, as a small district in Florida? Tell me how you're going to assure that my calls get answered and I'm prioritized.
Because you're going to have a dedicated person to you, so it's not like you're going to be having to call an office and find a lawyer that can help you. There is going to be one person that is going to be dedicated to the district, and then the way that we service the needs of the district will be funneled through that person. So if Mr. Cole needs assistance in, for example, desegregation, and he calls and says, listen, we need to find someone in our firm that's special, do we have this expertise? We will find that expertise and then bring that professional in for that, that particular matter. But there will never be a time where you will be without a person that you can directly contact by cell or by email, whatever the preferred method is, and get someone on the line to answer your questions. I have that relationship now with the current district that I represent. There's not a time where they can't reach me. They can always reach me. And I think that's part of, providing service to your client, that the way that you run your practice. I know that Mr. Cole and I both, we prioritize our clients and our clients' needs. It doesn't benefit you, nor does it benefit us for us to have a relationship that is not based on open communication and timely, communication, because, we'll also be making requests of you when we need information to fulfill our roles. And if we can't, get a board member or get a response, it's frustrating, just like it's frustrating for you guys when you can't get us. So I think that's part of the lawyer's practice. And for our practice, even though we are a larger firm, we still run our practice. We have a lot of autonomy and independence on how we run our practices, and I personally run my practice that way, and I know that Mr. Cole does as well.
Can I just add that an effective general counsel has to have a trust relationship with each of his board members. Otherwise, you can't do your job. You can't be effective. And you can't establish a trust relationship if you can't get me on the phone. And so, if I was going to be the general counsel, the first thing is everybody gets my cell phone number, and you call me whenever you need, whenever you have an issue. And I know those things happen sometimes at not real convenient hours or whatever. That's fine, because I know that you have to rely on general counsel to be there when you need him or her to be there. and to deal with these issues. And so they don't wait for a convenient time. So, you know, again, I've been a general counsel for a long time. I know the importance of that, and I was extremely available to all of my trustees at UCF. They would all tell you that. And because of that, they were really great about being open with me, and it made my job a lot easier.
Thank you. Can I ask another question?
Sure.
Because I want to take back, I had 3 minutes left over from before. Am I allowed to take any of those back?
I had 5.5. Can I answer?
Right, so my point is, I think we're running on schedule okay, even if we're.
Go ahead.
You okay with, yeah. So thanks, by the way, your reference to the whole tenure controversy, I remember it well. In your proposal, you discussed an hourly rate and a discounted hourly rate, but you did not talk about retainers or monthly retainers and any relationship we might have like that, which we've had in the past. Can you speak to that a bit?
Well, I think we'd be open to a retainer relationship. We typically do it at a discounted hourly rate, but we would have no problem doing it on a retainer basis for the bulk of the work. Obviously, if you have a litigation matter that's going to court, that's not really conducive to a retainer relationship, but sort of the meat and potatoes, the vast majority of work of the general counsel nature could be done on a retainer basis, yes.
Thank you.
That was short and sweet.
I didn't say it was going to take a long time. I just wanted to ask.
Berenborg.
I have 2 questions.
Yes, ma'am.
You mentioned availability just now. So if you are general counsel to UCF, what availability do you have to us for what nights to meet or during the day to meet?
Well, I was general counsel to UCF.
Oh, was?
Was.
Okay.
Yes.
Gotcha. So you would be available
Absolutely.
24/7,
24/7. Yes.
7 days a week?
7 days a week, and I don't put my phone on silent.
Okay.
So,
Bless you. The second question I have is lobbying.
yes.
You mentioned that you have lobbyists or lobbying as part of your firm. So have you had experience with lobbying for education in Tallahassee?
Yes.
For bonds?
Yes,
Okay.
we have a lobbying professional that is her sole specialty, and she also works, does some of that kind of work for the School Board of Broward County currently. And she's based in Tallahassee. We have the strongest and largest lobbying group in the state of Florida, also with an office and contacts in DC as well. So there is the former Speaker of the House, Dean Cannon, is our firm's managing partner. He heads the lobbying group. There is not a contact that Mr. Cannon does not have or that we cannot make if we needed to for the district.
And so would that be part of the package, or would that be something that we would have to negotiate above and beyond?
So if it's a particular lobbying issue, in other words, you're hiring a lobbyist for a specific issue, I think that would probably fall outside of the retainer, only because sometimes lobbying issues can take, several years or a lot of time dedicated to particular issues. But if it is just a general lobbying consideration, like you need us to make a connection to so-and-so individual, or there's something that we need to, I think that would probably fall under the general retainer. The only time that we would go outside of that is if there's some special or larger project that's going to require sort of dedicated time or a team that we know would exceed whatever general services we're providing.
Great, thank you.
Hey, Dr. Jones?
I don't think this is a question, just a comment, but something you said, Mr. Cole, about what public education can do for students and how they can get that step up to their next journey. And, we were all elected here in Inver County to serve on the school board, which is a public school board. And when we talk about DSEG plan or we talk about student achievement or anything, our focus is our students and what we need to do to assist them to get to that next journey in life. And I think it's just very important for whichever firm we choose, that's our focus on what we want to do for our students here in Indian River County in the public school system. In the DSEG plan, it's not like we want to check these boxes off and put it on a shelf. We want to achieve what's asked of us. We have an equity committee that evaluates that. So a lot of things we wanted to do as board members to help all of our students here. So, that just was an important statement to me because we have a diverse population here. If you looked at Indian River County, our ALICE and poverty population is around 53%. And we're working with many homeless students. We're working with students that struggle in many ways. So That's very important to me for whatever school board firm we choose, that they understand who we are in Indian River County.
Thank you for that, and I totally agree. I know from my personal experience, when I began at UCF, it was a commuter school, and John Hitt came in and really changed things, and his focus, his entire 26-year career, was on access to education and diversity and inclusion. He brought the institution to be a primarily Hispanic-serving institution. That diversity, inclusion, and access were all, and still continue to be there, the highest priority. And there's no reason, and in fact, it should be the priority at every level of education, right? Because everybody needs a chance to show that they can succeed. And in order to do that, they need a level playing field. And that's what a lot of these programs do. They just give people a level playing field.
We just added an access and advocacy department, so
Oh,
yeah, that's the way
excellent.
we want to go.
Excellent.
Thank you.
Mrs. Rosario, do you have any questions?
No, I'm good.
Good.
Thank you.
Sure, go
I
ahead.
have one more burning thought. You cannot answer it if you want. But, because I was a little confused, you made a statement earlier that you wanted to add this, because you were at UCF and were general counsel to the president and to the board of trustees.
Yeah.
And then I just heard you say that was former. Can I ask why you left?
Oh, sure. 19 years at the same institution is a really long time. We had a new president come in, and the new president wanted to bring his people in, and so about half the cabinet left with that. I'm amazed as a general counsel that I was there for 19 years. That's quite an accomplishment, but it was time for him to be able to set his own team. And so I said, great, best of luck. And fortunately for me, Gray Robinson came at the same time and offered me an amazing position to head up their higher education practice. And so I was thrilled to do it. And now, because I couldn't do this when I was at UCF, I get the opportunity to come and work at the K-12 level. It's a continuum. You know, education doesn't stop at one level just because they call it something different. It's a continuum all the way through to postgraduate, from kindergarten to postgraduate. This is the next step for me, and I just think it's, you know, it's exciting.
You'll actually learn as pre-K, birth.
Thank you. Thank you.
Birth.
Birth, okay, very good. Thank you.
So
thank you.
that about wraps it up. Is there anything else that you'd like to share with us that, before you leave, that has come up either in this conversation or any questions that you might have an additional thought? It's not necessary, but you get the last word, as they say.
Just because my mind I'm a litigator, so my mind thinks in litigation terms. In terms of the amount of litigation that the district is involved in, is that something that you typically handle in-house, or do you have covered claims and you work through a TP, like a third-party administrator, like usually districts use Gallagher Bassett, or Johns Eastern? So is that, are the claims coming in, are they covered under insurance, or is the district on its own self-insured?
Dr. Moore, why don't you respond to that? Go ahead. Or Ms. Agresta, better yet.
The school board is a member of, it's called SCRP. It's here in the Treasure Coast area, the South Central something risk management pool.
Okay.
I don't know the exact words. So there's 6 school boards that are a member of this trust.
Okay.
And so all of the typical tort claims are processed through that group. And so
Okay.
they're handled by lawyers who work through that particular group. Separate and apart from that coverage, the school board also has some insurance policies for errors and omissions, those sorts of
Okay.
things. And so they have approved panel counsel that handle items that are covered through those insurance programs. There are always some litigation pieces that crop up that aren't covered by either, which would require either outside expertise or the board attorney to handle.
Okay. Thank you.
Any other comments or
Well, I would
questions?
just say thank you for having us here. I know that all of you have a passion for education. You wouldn't be here. You have to go through a lot to be in the positions that you're in. So I share that passion with you. I've spent my career because I believe in education. I would love the opportunity to work with you. And I'm so thrilled to be at a place now where we have these amazing lawyers who literally can provide whatever service you need. I haven't had that before. So I think it'd be a great combination, and appreciate again your time for having us. Thank you.
Thank you.
Thank you so much.
Thank you very much.
Thank you very much.
Have a great day.
You too.
We want to take a 5-minute break?
Yeah, very, very briefly.
5 minutes. You can do your.
I'd be remiss if I did not just bring this. You've already read the proposals, but I just want to make sure everyone's aware. So this is a point in time at which we're going to just reflect and have any other discussion items we would like to talk about. Then I'd ask for you to complete the evaluations and let me collect them, and we'll go get the calculation. If you would like yours back, we'll make you a copy and give it back to you, so you'll have that for your reference if you need it. There was discussion during the interview with the second vendor regarding fee. So in the first one, Sniffen Spellman, they gave two options. One, a monthly retainer of $11,000, approximately $132 a year, or a flat hourly rate, and so there's multiple rates here, but if you just look at the attorney for $190. Gray Robinson only submitted a flat rate, a discount rate of $275 per hour. So I just wanted to mention that.
Sure.
Mr. Fagan, you sent me an email that Gray Robinson, they had a flat rate of 22,000. No, sorry.
No, it's in the.
22 is the current legal counsel.
Yeah, let me see if I can find that email. Remember the email that I sent, that I requested? Oh, sorry. I have the same question, board members. And I sent an email on October 26th to Mr. Fagan asking about the comparison of current fee versus the two. And so, yes, the current fee is $22,000 per month. Sniffen Spellman proposed an hourly rate, as Mr. Fagan just mentioned, at $190. But in their proposal, they offered a flat rate of $11,000 a month. And then Gray Robinson, oh, maybe it's not here.
There's no
Sorry.
flat, there was no flat fee from Gray
Yeah.
Robinson.
That's why I asked the question.
Yep, okay,
Yeah.
disregard.
And
I
the
don't know why I
fact,
thought there was a flat fee for them as well.
fact of the matter is, if they were willing to consider a flat fee, they should have put it in their proposal as opposed to. But I think at the end of the day, just to correct me if I'm wrong, if we're going to evaluate them, and that's obviously, but on the four broad topics, if in fact they're the firm that gets the highest number of points are selected, then I presume that Dr. Moore and Mr. Fagan could negotiate a flat fee if they're chosen. But that's not necessarily, I don't know how you could avoid it, but that's not necessarily something that we should consider based on the four questions that we're asked to rank them on. Am I incorrect in that?
That is correct.
How do you want this conversation to proceed, Mr. Chair?
Well, I think what we do, I mean, both presenters, I think, handled the questions well, and presumably as you've gone along, you've come up with a number, and if you put the number and add it all up, I think that at this point in time, I don't know that there's much else we can do, because and I'm unfamiliar with this, but I mean, if this were not a public forum, we could go back and forth on some of these things, but I'm not sure that's appropriate. Correct me if I'm wrong. Mrs. Rosario, go ahead.
I don't know if Dr. Schiff was going to respond to this, but the same thing happened when we hired our attorney, our superintendent. We had the interview and we had a public discussion at some point about what we thought were pros, what we thought were cons. And then we had our private time to kind of give the scoring on this rubric. So if we were going to have a conversation, it would be now. We are in a workshop. I mean, this is what we are here to do, to hire an attorney, which next to the superintendent is the most important position for a school board to hire and to make this decision on. And so if I can, I know Dr. Schiff had something to say prior to you calling on me on this issue, so I'll just hand it over to Dr. Schiff.
Similarly, I'm interested in hearing what other board members thought. I'm interested in, I don't know if we can or not, so maybe we need legal guidance on this.
So, through the chair, if I can, this in fact is the opportunity for that
Yeah,
discussion
that's
that
what I
both
thought.
Ms.
Yep.
Rosario and Dr. Schiff is referring to. So I would encourage the board to, very similar to what Ms. Rosario just said, this is your one and only opportunity to have that discourse. So now is the time. And then after following the completion of that dialogue, We'll give you a few moments to fill out the form in silence, and then we'll collect them and go through the next items, and once it's all tallied up, we'll come back to the board with what that scoring is. But feel free to take this time to discuss.
All right, Ms. Barrenborg, go ahead.
Before we discuss, I have a clarification question, because this is a little different than hiring a superintendent, and that is because we went through an RFP process. So I would like to ask the school board attorney, are we okay in discussing before we score?
Absolutely. Just like any other procurement committee would hear presentations and discuss amongst themselves before they filled out their scorecards, or to get clarification amongst, their colleagues before they fill out their scorecards. This would be your opportunity. I would just provide you with the same, it's not really a caution, but with the same information that was shared during the superintendent search. During this discussion, be aware, it is a public meeting. So please try not to be negative about an individual or their experience, only because these are people in the legal industry. They are representing other school districts. I would hate to, and I'm not suggesting that you're going to, but if we could just not be negative about the people that came to present to you.
Okay, go ahead.
Thank you. Thanks for that clarification. First of all, I thought they were both outstanding, had outstanding firms. There's no negative that I can look at. There were some things that I thought were... Your mic. There were some things that I thought were interesting to weigh, however, because we are weighing basically this decision between two firms. So there were some things that I thought I was jotting down as I went back and forth. Yes, fee is important, and that's something that we need to look at and consider. But I think there are other things that are just as important. First of all, the one thing on the first candidate, Sniffen and Spellman, their DSEG experience I thought was quite valuable. The no travel expenses was something to consider, because living locally, and I did see in the RFP packet that they would not charge us for travel. They have a lot of school board experience and sitting on school boards. That is a positive and yet a concern, because they are on other school boards. So I do know that sometimes it's hard to compartmentalize when you're working with different agencies, and so that might be a positive, it might not, I'm not sure. As far as the second candidate with Gray Robinson, the availability, it was a huge issue, I think, that was very supportive of them. Mr. Cole's ability to be available whenever we would get individual focus. His travel was something to consider, that we would have to, again, pay an attorney to come from Orlando, because we're used to doing that. Thank you, Suzanne. School board experience is not something that he has in his back pocket, but I think his experience at UCF is extremely valuable. So I'm not as worried about that, because I think he would make it his main focus to be very versed on that. His experience with Robert's Rules was, I think, an impressive thing that's very helpful for us. And he was able to answer questions, especially that last one I asked, in a very, I thought his demeanor was very, very good. I also thought the other attorney's demeanor was very good, but I thought the way he answered that question, they also asked a question of us at the end, which I thought is an important thing when you do in an interview. And his 19 years in one place shows me that he has the willing to commit. So those were some positives I brought from both of those interviews.
Okay, Ms. Rosario?
I don't disagree with what Mrs. Barrenborg has just mentioned. Something that I found pretty concerning for an RFP is that Mr. Cole was not listed anywhere in the interest packet. Nowhere, not a biography, no anything. Although I'm glad that he was here, I'm glad that there was clarification, that it wasn't Anastasia Protopapadakis who would be representing us. But the fact that we didn't have any prior information on him to give us an opportunity to research him and his background better before this interview, that's a concern. The fact that they didn't first introduce that he wasn't in the packet and that we have, as a firm, decided that we would proffer Mr. Cole as your general counsel at the onset of the interview, that's a concern for me. How do we know that something like that isn't going to happen and they're not going to better communicate with us ahead of time, even if it were through Mr. Carver or Mr. Fagan by saying, you know, just a little heads up, we have changed things around in our firm and this is going to be who your general counsel might be instead of, you know, Anastasia Protopapadakis. I do think that they had a great, Gray Robinson had a great array of lawyers with various experiences. So if, for example, we were I could see the benefit of that if we were working on settling land or doing something with the Graves property that was donated to us. I can see the partnership and dealing with their firm having other people who have real estate and land experience, land use experience, and that sort of thing. I can see how that can be a positive for us, but I honestly, I think that Sniffen and Spellman is really the better option for us. For me, I think that they have much more in-depth school district and school board experience. I think the idea of being local is a benefit, all the things that Mrs. Berenborg just mentioned. My only concern is multitasking three districts. That's my only concern. I don't know how that's going to work. And if Sniffen and Spellman are our first choice, then we have to think about what our school board meetings are going to look like. We obviously cannot have our school board meetings on the same days as we have now, so that changes pretty much everything about how we do business, or at least the discussion here moving forward about what that would look like. So those are I guess, my biggest takeaways. But honestly, I think Sniffen and Spellman would be a better fit for this district for us here. And I think all the other things that are a concern we can kind of work around, but it's still something that we need to pay attention to because that's going to be the next decision. If we choose them, what are we going to do about our meetings?
Dr. Jones.
When I look at all my notes, I'm just in my head trying to think who would be the best fit for Indian River County. When you look at the information that they each gave us on their experience and people that could help in most areas, the qualifications, I think they both did a very good presentation at the beginning and answered the questions well. But I'm thinking, who's going to fit here with Indian River County? Little disappointed that Gray Robinson didn't know about our DSEC plan. That's huge and what we've been working on for years. Molly, our first person, obviously she has dealt with that in St. Lucie and Hendry, I believe she said it was. You know, that's something. I believe that, Gray Robinson had some very good information on if we needed someone in this area or this area or this area, they could be there for us. I would certainly want, as they said, they would have Mr. Cole here for us on a regular basis, which is what we would need. And we need access to our attorney for calls and emails. And just like whenever I email Ms. DeGresta, I get a return call or an email. And I really appreciate that. Even though it's a little issue, I appreciate that. They both seem okay with Robert's Rules of Orders, parliamentarian. They'll step in when they need to. the collaborative approach, I see that on both of them. But I'm just still processing, who would be the best person. Now, I believe that they said fourth Tuesday, Sniffen and Spellman are available. Is that correct? So if we chose and if we negotiate and that works, like Ms. Rosario said, what would that do to us as far as our meetings? And I'll be honest with you, if they are the, whoever we choose, I think we could probably work around that so that we have the best counsel we can have for the school board. So those are my thoughts thus far.
Dr. Schiff?
Thank you. I have to say, I am surprised. I walked in thinking one thing, and I'm walking out thinking something different. And I'm surprised, because that's not how I thought my reaction would be. I appreciate Sniffen and Spellman's school board experience, DSEG experience, all of that. I think they have certainly the experience and capacity to represent the school board. They are less expensive, that's true, but as Mrs. Berenborg mentioned, expense isn't always the sole criteria on which we evaluate. What I appreciated about Gray Robinson, their answers were clear, direct, succinct. They understood every question clearly and gave an answer that was directly responsive to the question, and I appreciated that. They, while not as well-versed in school board experience, what I also heard is it's an area they're really interested in engaging in. And if we are the first board to do that, I think there is some desire to make sure it is done well, and that it is, if it is an area that they're adding to their repertoire, you want to establish a good reputation and competency in that. Competency is not the right word. They're clearly competent. I appreciated, as Mrs. Berenborg mentioned, the higher education experience of Mr. Cole. I appreciated his clarity and directness about what he brings as an attorney when faced with difficult issues as well. I think either firm can represent the board. I don't think we necessarily go wrong. I think it is a question for us as a board of the kind of representation that we are looking for moving forward, the kind of board that we want to be, and the structure that we are creating as a board. It's an opportunity for us. Ms. DeGresta has been with us for a long time. We're very used to her style. It's an opportunity for us to make an active choice about how we want to move forward in our relationship with our attorney. So both firms are clearly competent. Yeah, I agree with Dr. Jones. The confusion around the DSEG questions was a yellow flag. Not because they're not competent, simply just because they don't have experience. But that doesn't mean that they don't have it elsewhere in the firm, or they can't learn it, or they are not able to marshal the resources necessary in order to get up to speed on that issue. So, yeah, so I know that I come out of this feeling differently than I went into it, which I appreciate the interview process. And I'll be interested in seeing then what everybody's, I assume, Mr. Fagan, that the score, we had scored the proposals, and then you will take those and add those to the scores of the interviews, and somebody will emerge victorious, presumably, and from there we will go to negotiating some kind of a contract. Is that correct?
Carver, are we going to add the two together or just use this last one?
The intent of the first scoring instrument that you completed was to identify the short list and score. The final scores that we tally from this exercise, that's where we will arrive at the winner.
And will that information then be brought back to the board for any discussion, or will you simply move ahead? So for example, in the question that was raised earlier about, so one thing that Mr. Cole said was he would provide, in effect, office hours, right? That he could be here another day. If we are, what was not part of the application was this idea, as we talked about, this idea of a retainer. So when we went for a superintendent, there was a significant negotiation process about that contract. And I'm wondering how this works and what is the board's or the board chair's role in negotiating that contract, or if there is a negotiation. I've never done this before.
Through the chair, today when you finish, we will take those scores and go back and tally. Whoever is the selected firm, we then begin negotiations with them. And that is the process. So if it happens to be Gray Robinson, we will bring up the suggestion of the flat. They may say $5 off. They may say $1,000. Who knows what it's going to do? Then we have to negotiate that to see if we can come to a consensus. If we can't, then you might have the opportunity to go to number 2.
I think I am feeling that tension. I often feel as a board member where our job is 30,000 feet up and sometimes we want to get into the weeds, and I'm feeling a bit of that tension right now is all.
Well, this is your weeds. This is
Well,
your hiring process.
It's my weed to decide who I prefer as an attorney. It is not my weed to negotiate a contract. It may be
But-
my weeds to have some input into how that occurs, but that's
Yes.
not the way this structure was set up. And there is a fine line as a board member between the degree to which we receive information and make decisions about that, and then we get into day-to-day management of the district, which is not our job.
All right. Through the chair, if I can. Through this process, you will arrive at a selection. All right. You've made your decision. You've put your best foot forward, and both firms have already been decided as being qualified. So there's no real right, wrong answer. Now it comes back to administration. Go negotiate the best contract you can for us, which now takes you out of that arena, and now that's on us.
Yep.
And then on the 29th, we come back and say, based on your results, we've gone back, tallied, negotiated with the firm, this is the best contract we can come with, and this is what we're presenting on the 29th. So we're kind of separating you from that once you make the selection.
All right, I'll weigh in, but go ahead.
And I just wanted to follow up, if that's
Go
okay.
ahead.
I heard that Gray Robinson or Mr. Cole, for example, might be, or this board might be the first, I think Dr. Schiff mentioned, might be the first to hire someone who doesn't have school district experience. And while I think that might be a possibility for us, if we had a team of lawyers that we can fall on for experience, but without Mrs. DiAgresta here, I don't think we have the playing field to take that chance. I think that we need to go with someone who has school district experience specifically that would meet our needs on day one, where we would not have to worry about someone who does not understand ground level, lower education work versus, post-secondary education work. I'm not saying that he's not qualified for it. I just don't think that would be the right fit for Indian River County where we stand right now, especially with our desegregation order, and especially going to seek unitary status or, wherever we would be in that process. I just don't know if we would, I know that we shouldn't take that chance right now. We should go with someone who can well represent us on day one, and we'll have to figure out all the other challenges around that.
Okay, so quickly, I look at the 4 boxes here. I have both A and D, I have both of them rated the same. I
For
think-
which one?
What?
Are we
For which
supposed to
one?
discuss
We're
our
not talking
scores?
about that. We're not talking about our individual
No,
numbers.
I'm just saying that they both did a good job in terms of experience.
We're not,
He's not giving his points, he's just talking about his view, that's all. He can do that.
I mean, everybody's said what they thought was good or
Yeah.
better. I think they both did a nice job. I'm just saying that the experience of the law firm, they did a nice job. I thought they handled the questions well. I think the difference, in my opinion, was the Gray Robinson presentation was a little smoother. What I particularly liked is the risk assessment, because spelling, I get them mixed up. Sniffing and spelling didn't really answer that question, whereas if you're coming into a new situation, you would normally expect, if it was a corporate setting, you know, a new CEO or a new chief auditor would immediately do an assessment so to find out where they are so that you can identify sort of where you're beginning from. So I thought that was a plus for Gray Robinson and a little bit of point of differentiation. But at the end of the day, the lack of hands-on experience in desegregation cases, unlike sniffing, an experienced attorney, despite all of the perhaps challenges around scheduling, I just think that's where Molly, experience, and with school boards, it's also, you know, I guess you could say there's some benefit to having the same attorney, while it could be a negative, as you point out, servicing the Treasure Coast. There are some similarities. So that becomes a little bit of an advantage for sniffing. So at the end of the day, as good as they both were, and I would not be unhappy with either one, I just think that the experience, both on the DSEG and in school boards, gives the benefit, the nod to Sniff and not to Gray Robinson. But they're very good. I mean, there's no question about it. And Dr. Schiff, your comment, we all tend to have a perception from a piece of paper as to what to expect. And I do think that Gray Robinson surprised me. I thought they were, not that I thought they were going to be bad, they were better than I thought they were going to be. But I go with the experience of sniffing. Sure?
sorry for jumping on you, by the way. I misunderstood what you were about to do, so I apologize publicly. One thing I would also invite us to consider is how we think any of these attorneys will represent us under stress and duress. I think that we have been experiencing some challenging times, and we may be going to experience some challenging times. So how we think either of those attorneys will best support the board moving forward in that, I think is worthy of, for me, is worthy of consideration. I think there were some differences. It's a little hard, people sometimes, as you alluded to, Mr. Barefoot, people present differently on paper and in person. And I think we all felt that in the process of reading these descriptions and then seeing these representatives in person. As we move forward, I think there are going to be some difficult moments, and I want us to make sure that whoever is the attorney representing us in those difficult moments has a strong capacity to do that, a strong, confident ability to know how to guide and support the board in some of those difficult moments, and I would ask us to consider that as well.
Okay, any other comments? One more?
Sure. I have a hard time, I'm fine with either. I know financially, there's a big difference between the two, but we're not being asked to consider that, which it's bothering me that that's not part of this decision-making. But, and I know back in the recesses of your minds when you're scoring, you might be considering that. Again, to consider just the interview, to me, there were some very positives on both sides. And that's why I had a hard time with this. because it's very frustrating. I agree with you, the demeanor, I felt on one would be a very calming demeanor. I'm not saying the other one wouldn't, because I haven't seen that in action. So again, in an interview process versus on the dais, you might see totally different demeanor. You don't know, because we haven't been able to see that. So that is just something that, yes, I understand what you're saying, and that's why I said to the superintendent after we're done the interviews, that's why they play the game. And the reason why I meant that is because on paper, UCF probably would have been, champions of the world this year, but they play the game and they're not. So when I read the papers and the packets, I had a very strong feeling towards sniffing and smelling. And then they came today, and I was really pleasantly surprised by what I saw with Gray Robinson. But I agree with Mr. Rosario. I was very taken back by who was going to be the board attorney. That's why I asked the questions I asked, because I really wanted to get a clear understanding of who was going to be representing us. So, yeah. But I do also know that things change all the time. And if you have a big firm, then you have the ability to bring somebody in because, Suzanne hasn't been at every meeting, and she brings in a substitute that tags well and comes in and helps us. So I'm not concerned about the fact that either of these firms can do that for us. So, yeah, I had a hard time scoring this.
All right. Yep.
Chair, then if all the board members are done, I'll collect the forms and we can move on to the next agenda item.
So are we done? Do you need a minute, or?
I think we've discussed
I
it.
guess so.
All right, here we go. Collect them, Ron.
I just want to apologize for anyone in the room if you see me putting my head down. I'm just fighting a migraine. No, I'm just fighting a
I know, but
migraine.
you have me concerned.
Thank goodness Dr. Schiff has some essential oils here, so
Oh,
that's,
boy.
I don't want to be disrespectful to anyone. I just wanted to,
Public record, the essential oils.
so I do apologize.
So as Mr. Fagan mentioned, him and Mr. Carver, and absolutely, Mr. Carver, thank you for leading us through this process. Very, very hard, complex, but I think you did an absolutely outstanding job moving us through this process. Mr. Fagan, thank you for keeping us on point. I know we wanted to make sure that we conducted ourselves in a way which brought honor to our community, and I think we just proved that we were able to do that. The next item on the agenda is Ms. DeGresta. So to present her final item. No, I'm kidding.
I won't have to talk anymore after this? Okay. Board members, you may remember at your last workshop, we had a discussion regarding the voting districts that the County Commission is currently working on revising, and that tentatively you will be approving as your new voting districts. And one of the items attached to this workshop item is the map. It's proposed map 1B as in boy, which the County Commission discussed at its last business meeting and tentatively approved to move forward to be their final map. So in December, the County Commission will hold its final meeting with regard to the selection of a map, and they will have the map that they tentatively approved. They will have legal descriptions of each of the voting districts, and they will have their final approval. Once that occurs, the school board would then be in a position to also have an agenda item at your December meeting to approve the new voting district maps and the legal descriptions. And just to be sure that we keep ourselves on schedule, I actually already mocked up a proposed resolution for the board to approve in December once the County Commission gets done finalizing the map and attaching legal descriptions to it. So the purpose of this agenda item was really just to bring that information to you. We discussed it the last time to let you know that, yes, in fact, the County Commission did pick a map. You have a copy of it attached to this particular agenda item. And at your business meeting, your 6 o'clock business meeting this evening, there is also an action item for you to articulate your intent, which you had asked to do at the last workshop, for you to articulate your intent that you would be adopting the same map as the County Commission. So you can certainly do that at your business meeting this evening with the understanding that the map, the legal descriptions, and the resolution will come back to you at your meeting in December for final approval. I'm happy to answer any questions that I can.
Questions, anybody?
All right, next item will be presented by our Director of Innovation, Ms. Cindy Emerson. and it is the instructional calendar for the upcoming school year.
All right, I believe that they're going to be pulling up the presentation, but I just want to first say it has been such an honor the last 2 years working with the Instructional Calendar Committee. It's very humbling being a part of a committee that involves so many stakeholders and having the opportunity to hear input from various groups throughout the community. And while I just facilitate the committee, it's been a great honor working with so many great people throughout the district. And so we always start with our unified mission and guiding principles, and that is to transform education and inspire and empower all students to maximize their full potential. We were tasked last year to create an innovative instructional calendar that maximizes instructional time, creating the best systems for SDIRC growth. And you know, these members of the community, IRCEA, CWA, we brought in admin and staff as well as district staff that this impacts, including payroll. Having all of them a part of this allows us to move slow to start with, and then that allows us to move fast by creating norms and establishing some feedback from our community as a result. And so we always follow our norms with our meetings. We take time to survey the committee. We have opportunities for committee feedback, and then we've been able to create assurances that have allowed us to not only develop the calendar for next school year, but a tentative calendar for 2023-2024, which has been posted now since February of 2021. And once we are done with our meeting today, we will post the tentative calendar for 2024-2025. And so this is the restructuring of the calendar, which includes also a back page that we've added on last year just to give a little more detail for our families and our teachers and staff. And so we are coming forward with our recommended instructional calendar to the board. We have continued with eliminating the 16 early release days, which has allowed us to increase 21 instructional hours and provide more stability for our families. That was a major source of feedback from our families and parents in the community, that those days were very difficult for them to establish childcare. And while those hours were important, a lot of times in an effort to transition to the professional development, there was a lot of time lost even getting there. So what was intended to be 2 hours of increased professional development, sometimes 1.5 or 1. And this allowed for more distraction, or less distraction, and more time on task during those school days, those 16 school days that are no longer cut short. So we consider that a big win. Another big win was finally getting it on record that the Veterans Council approved us not having school on Veterans Day. And so that was a big win for us, where in the past we had been going back and forth each year. This allows us to really focus in on what the intention is of the Veterans Council. And so that was a big win for us. Another huge win was just giving teachers autonomy and choice in these 4 optional days for teacher planning. And so from the 4 days that have been built into the calendar, they pick which 2 are beneficial to them. And having that autonomy and choice, you know, we're treating our teachers like the professionals that they are. We also have added 2 full focused professional development days. And so this allows our principals and our district staff to develop PD that really can dig in deeper and take a lot more time to really go through the process and scaffold. And so we have 1 in first semester and 1 in second semester. And then another big win, and the one that I probably most honestly get the most feedback for, is just how much more user-friendly the calendar is. People understand with the reformatted layout, the orientation days, the open house dates, graduation dates, everything is on there along with conference nights. So they don't have to bounce around the website. They can really get everything from the one location, front and back of the calendar. And so with this recommended calendar, it has been posted for our families and our staff since February 2021, with only minor adjustments from stakeholder feedback. We did have unanimous approval of the instructional calendar that is being put in front of you by the calendar committee. And we have the 2023-2024 draft tentative calendar posted. Next year, we will again meet with the calendar committee, and we will go through the same process of approval. And once we're done today with the instructional calendar, we will then post the draft for 2024-2025, which I know it seems like really pre-planned in advance, but because we've established norms, we really can pre-plan this out so our families can make decisions in advance for them. So I just want to go through really fast what the process is for the calendar committee. So we have 196 days scheduled for our teachers, and August 10th is the first day school may begin. And so with that comes 6 recognized paid holidays off. So when you see holiday in the calendar, that is what the actual payroll is having as our 6 days off. This leaves 10 days for PD, planning, wrap-up, etc. Dictated by contract, 1 day after conferences for first semester, 1 day after conferences for second semester, would take 2 of those 10 days. The request from our staff was to have 5 pre-planning days prior to the start of school, so that brings us to 7. We have the 1 day when we return from winter break that was established, so that brings us to 8, and with the 2 optional days, that brings us to the 10. And so I know it seems like there's a lot to work with, but once the norms are established, there really isn't much space and wiggle room within the calendar. What we did add last year was those 2 additional professional development days, dropping from 180 to 178 for student days, because we removed those early release days. But even with that, we added an additional 21 hours of instruction. And as I mentioned earlier, those 16 days are a lot more meaningful when they're not being cut short. So the process, we sent out the survey for all parties interested in joining the committee, and we have 27 members of the instructional calendar committee. It's one of our largest committees in the district. And through the efforts of surveying, we're able to move pretty quickly now because we've established our norms, which are right here. The Veterans Council approval, elimination of the early release days, the increase in instructional hours, the 2 full days for professional development, along with adding choice for teacher optional days, and maintaining that 196-day teacher calendar. And so we use the same assurances that we put out into the community last year to make sure that we're just following through with what the voice of our stakeholders has said. And so the 2022-2023 calendar was voted and approved in September of 2021 this year, and we only went back and did a minor adjustment, which I'm sure that you noticed, adding October 5th as a day off and pushing back winter break to start on December 22nd. There was a long 8-week period full, and so they did feel like it would be better in the first semester to add an additional day in that space and take 1 day off of that winter break, still having the 2 weeks off at least. That has been the community feedback of what has been expected and interested. So that's where we're at with the process.
So I just want to acknowledge Ms. Emerson. I think 2 years ago, this was a big, long, drawn-out process where there's a great big debate and a lack of focus, really shifting us to a professional organization where we present items to the board in which it does, in fact, have community consensus, really doing the long-term planning and creating the conditions over the course of time where families know typically when the schedule is going to be. So this is a body of work that once was hard and complex, but now ultimately comes before you in a great deal of consensus in building partnerships as we present this calendar. So with that, we'd be happy to answer any questions you may have.
Oh, thank you. First of all, yes, thank you for the organization on this, because I did attend those meetings a couple years ago, and this is a vast improvement. There are two little comments I had written down. One was about Veterans Day, because that was a bone of contention in the past. So we do have verification in writing that the Veterans Council definitely wants us to be able to take the day off, correct?
Through the chair, yes. And I was able to, and since you mentioned it, I'm going to make a plug. My first Veterans Day was in the midst of the pandemic. But just this past week, had the opportunity to see what Veterans Day is all about here in Indian River County. And this is an absolute validation as to why we need to be out celebrating and honoring. Went to 2 or 3 different events on that particular day, and it was just so powerful to see. Our students were at all of them participating, whether it was marching, whether it was speaking, whether it was presenting the flags, whether it was playing an instrument. It was an absolute outstanding day. But yes, we do have that validation.
Yes, I'm sorry I missed it. I was out of town with a family illness. I will say that when I looked at this calendar, I found it interesting that Halloween is a day off, whereas teachers would probably prefer the next day off. Just saying. It's just a comment. I did notice that's a long weekend that we put in here, and we had it off again this past year, that long weekend. Okay, so you suspect that that's going to continue, that long weekend in October? Okay. That's all I had.
Any other comments, questions? Dr. Jones?
Last year, I was very grateful for making sure that we had school all day on Wednesday. I couldn't remember if I was coming or going on those days. You know, do I plan the PD? Does the district? And kids got out of sync, so I'm very happy with that. I know I'm the OG here, but do you remember when we went to school Thanksgiving, Monday, Tuesday, and Wednesday? Okay. Everybody, this is nice, this week off. It's so nice, you know? The optional PD days, I like those, Ms. Emerson. So those are PD days offered by the district where the teachers can attend? So they're not school-based, or are they school-based?
So that came up, and what we said, and what you'll see a minor change is staff professional development is what they're being called. And so principals will be offering professional development, but so will the district. And
Okay.
so the hope is that it would give teachers autonomy to choose what would be most
I
beneficial
like
to
those.
them.
I like those. And I remember as principal Gifford and Sebastian, I scheduled exams before Christmas, before we were off at Christmas. So I had to do stuff with the DOE, but boy, it was just so smart for the kids. You know, it was just so
Right.
smart. And Dr. Moore, just a question. I don't know if you've seen, I think it was Brevard County, a couple others, where they're extending Thanksgiving break because teachers needed more time off, and they said no school on Friday after Veterans Day. I mean, those issues around the country. How are we doing on subs and teachers?
So, to the calendar specifically, those first 2 op days belong to the teachers.
Okay.
This was the first year that we did that. We needed a better job of making sure our principals are there to receive the teachers. They can have their keys, they can get in their rooms, and they can do their own individual planning on those particular days. Professional Development Day, which is a solid day of professional development. We just had the opportunity to debrief that, and we think the second one is going to be even more intentional to ensure teachers have what they need to be planning. In terms of substitutes, it is a national shortage, and we have a structure in place through Mr. Bass in his office. If they need additional support, they being principals, they would contact him, and we can deploy district staff. We are using, in some cases, instructional coaches. We have long-term substitutes. We do have a little bit of flexibility in which additional compensation is provided for a long-term sub versus a regular sub. If we use a CWA employee for an extended amount of time, they also receive an additional compensation. So there's some things that were naturally in the contract which help us to do that. We look at open positions every single week in order to ensure, do we need to deploy? We're in a much better place than most districts. And speaking to other superintendents, and you did mention about bus drivers. So Mr. Bass, just to follow up on that, you saw a lot of bus drivers who are coming off. For the first time, we have an additional 10 bus drivers above and beyond our routes. So what that means is if we have 7, 8, 9 out, we're still good. We don't have to combine everything. So that was an initiative that Ms. Idolette brought forward. Mr. Fagan found a way to fund it, so that's going to help make sure that we have every single route running every single day.
I just want to be aware, you know, last year was tough, but if you talk to educators, they say this year even seems to be tougher sometimes for different reasons, and I just want to make sure that our teachers are okay.
Okay.
So our next item, I'm going to present them together, was Mr. Fagan, followed by Mr. Bass, and they're going to both review the contracts that have been briefed with board members for their very specific areas. And Mr. Fagan, you'll begin.
Yes, through the chair, I have two items. One is the construction management services to build the classroom addition at Sebastian River Middle School. It's approximately $8 million. The winner of that process was Proctor Construction. The second item is a piggyback for solid waste collection through a piggyback contract with Brevard County. Approximate cost over 5 years is $1.5 million. Any questions? Thank you.
Good afternoon. Through the chair, bringing to you the final retainage payment, Proctor Construction, for the locker room renovation at the FLC boys and girls locker room. Each locker room received new epoxy floors, new lockers, created a better line sight for supervision, new toilet fixtures, new partitions, new PA speakers, and IP clocks and paint. This will close out the account and be the last payment due to Proctor Construction.
Thank you.
Anything else? Okay,
That is-
thank you very much.
That is it, and through the chair, Ms. Dampier will present. As you know, we go through our adoption of policies, Neola policy. We just spent a lengthy amount of time working with our school board attorney through Ms. Dampier's office. Then those items, specifically the policies, go back to each specific cabinet member who's responsible for that area of work. They review it to make recommendations back to the board. We then take those policies and we meet with each individual board member to review the shifts in policy based on Neola recommendations. Following our conversation, there were minor edits that were made based on feedback from board members. Ms. Dampier sent that information to each and individual board member. It was a very tight process, and I thank Mr. Dampier for her leadership, keeping all of the cabinet members on task and presenting such a large amount of information to board members is not an easy task. And this is always in the winter. You have the big load of policies because of the shifts based on changes in statute. And the overwhelming majority of statute changes in policy here all relate to shifts and changes in statute. So with that, Ms. Dampier will present the item, and we will be able to answer any questions you may or may not have.
Through the chair, I bring forward volume 22, number 1. This is our first set of Neola policies for our fall session. You know, Neola provides 2 updates per year, and this is our first one. We had 48 policies. We had the opportunity November 1st through the 4th to meet with each board member to review policies and take recommendations, and those changes were sent out last Tuesday. At this time, do you have any questions pertaining to any of the policies?
I do. I have just 2. One was a spelling error I caught after our meeting, and that was on 9800 charter schools. I'm not sure if somebody else caught it. On the second part where it says B, on the highlighted area, if either the charter school, it says Cartier School. So I just want you to make sure that it's spelled right. It's just a small spelling error, but I
Good
know
tip.
that matters on this. It's under B, charter contract negotiations, the part that's highlighted.
You got it.
Okay? And then the other question I had is, when you meet with school board members to do this, is it edits like that, like small little spelling errors or something like that? Or statute changes or major changes? Because there was one at the bottom of 2417, comprehensive health education, that I wanted to know if this follows exactly what the statute says. It's something I used to teach, that's why I'm kind of familiar with it.
What's the name of the policy?
Yes, the policy is comprehensive health education, 2417.
Okay.
Okay, that would be curriculum, but we'll do our best.
Okay. On the very, very bottom, where it's highlighted, it says, "The board shall annually approve all instructional materials used to teach reproductive health or any disease, including HIV/AIDS, in an open, noticed public meeting." Is that something a school board member added, or is that something that's statute?
You can say it just as well as.
Mrs. Berenborg, during the last legislative session, that language was dropped into the statute
Okay, I want to make sure.
regarding instructional materials. And so Neola literally just pulled statutory language and dropped it into the policy.
Okay,
So-
I want to make sure that we're
Yes,
doing
ma'am.
that, especially on a sensitive topic such as that one.
Yes, ma'am.
Okay. And again, my other question about school board member edits.
So through the chair, the overwhelming of edits just are that they're grammatical or preference or more specific to us here in Indian River County, not changing anything that's in statute. So overwhelmingly, what we're seeing here are changes based on statute. We're not seeing a board member saying, well, take that out, we don't like it. That's what we
Okay,
pay Neola
I want to make
do.
sure that's
Yeah.
not happening, because I'm not privy to those conversations, they're not privy to my conversation. I just think that when I vote on something, I want to make sure we're following the letter of the law.
Absolutely.
Okay,
And we have the attorney available as well, so no, we're following, we always reference this is revised because of statute, because of legislative changes and that sort of thing.
okay, thank you.
Okay, any other, Dr. Jones?
Just a couple comments on 8452, the AED calls for employee volunteer who is reasonably expected to use an AED to be notified annually of the location. That seems pretty, we do a lot more than that.
Through the chair, and it's interesting, and
I
that's,
used to
that
train
is
every-
validation, Ms. Berenborg, that we
She
don't
doesn't know my
share.
conversation with you, so I'm glad you brought that
I
up.
didn't bring that, yeah.
No, she-
I
she-
would tell you, I used to train my administrators, my coaches, and those AEDs were all over the place.
Through the chair, so way back when I was a principal, same with Ms. Berenborg, and Ms. Berenborg, I don't know if it was your site specific, under your leadership, or
No,
your county's.
the county
lead-
told us we needed to do that,
Yeah.
and I made sure we did it
Right,
more
and
often.
If you don't mind, would you like to share, or?
Sure, sure.
Go
In
ahead.
St. Lucie County, we had to do just like a fire inspection or fire drill or tornado drill, you know,
We
Pam,
do
'cause
that,
you were a
we do
principal.
that here
Okay,
for the AED.
but our specific drill was different than what he and I discussed last week.
Okay.
So I want to make sure we're very clear on this, because we have AED machines now in all our schools, and it was because of a tragedy that I know Dr. Jones is very familiar with, Michael App. And I spoke to his mom recently, so I know that this is something very sensitive, that we make sure that those aren't just on our campuses, but that people know what to do in case of that emergency, how to handle it, where it is, so it's not second thinking, it's just, this is like a drill. We just grab it and go, we know what to do. So we used to do the drill every month, where I had to call a special code, and just those people on the AED team would run to the location that we thought, I would say, PE field or whatever. They would run there and actually assimilate doing the AED procedure on a student, which there would be no student there, but it would be a simulation to use the machine. So A, they remembered how to use the machine from their training, because you get that training once, or once a year. And then B, it takes the guesswork out of who does what. Who gets the machine, where does it go? Oftentimes, we would have two machines located wherever we were, and that's a good thing. So I just want to make sure that we're doing that practice like we do fire drills, tornado drills, hurricane practices, things like that.
And through the chair, I think we do the basic drill in terms of location, but we are going to add that practice, as we discussed, very similar to what Doc Jones discussed, where we're going to create that mock drill, the exercise, to ensure it is in fact happening, because you get nervous when something like that really happens.
Yes, I want to make sure, so thank you. So it's second nature.
And the only other one, it was just basically a question on ESE and, student takedowns, or, looking at that. Yeah, and I know that we have training for that, and I know at one time we had an issue with some of those things. So how are we looking there now, Ms. Dampier?
We're constantly, just so you know, we're constantly monitoring our restraints. As a matter of fact, that's part of my monthly meeting with Dr. Moore, and we've actually reduced our restraints up under the direction of our new director. We've been providing additional training for our staff. We just held a full day of training on November 1st for all of our VE teachers across the district, and provided that training as well as making sure that everyone knows that we don't use seclusion, and what type of restraints to use, and that they are trained extensively, and that's the last resort.
Good, yes, ma'am. I am not a member of the ESE Parent Advisory, but I always zoom in on the calls, and I just love the parent involvement.
Yes.
Proactive measures we're attempting to do every day, and really looking at what's best for our kids. It's good. Thank you. That's all.
Yeah, a couple things. This may be statutory language, it may be rewrote it, but forgive my pickiness, but the grammar's all off, and it doesn't make sense. On 2520, and the same stuff is repeated in a few places. It says parent objection to instructional material used in the classroom. Should I keep going, or do you want to find it?
2520.
It's also on 2111.
There's a few, and the paragraph is not logical. It says, parents may object to the use by their child of a specific instructional material in the classroom as set forth in Florida law if they feel the material violates the provisions of, 106.26, et cetera, Florida statute, which states that material may not, contain content that is pornographic, remember, we're going from may not, be suited to the student needs and their ability to comprehend the material, or be inappropriate for the grade level and age group for which the material is used. So Florida statutes, which states material may not or be inappropriate for the grade level, it doesn't make sense. So could you review that?
Yes.
Through the chair, well, that's pulled right from the statute, but I agree, it is confusing. It is
Yeah,
confusing.
it doesn't make sense. And there's another one, and this is a clarification, and again, maybe statutory. And I'm afraid I don't know where it is. I'll find it. It states, parents of district students have a right to access school safety and discipline incidents as pursuant to Florida Statute 1006.7, parentheses 9. Can you clarify, do parents have the right to access school safety and discipline incidents specific to individual kids, or just the incident, or what does this mean? Because they can't access records of other kids.
No.
Hi.
That particular language was added into statutes during the last legislative session. It's referring to assessor data. So, and I'm not going to know what all those letters stand for, but assessor data is collected from every school, but it's aggregate. So assessor data is available to parents.
Parents of district
aggregate.
students have a right to access aggregate student safety and discipline incidents.
Assessor data is aggregate, so
Right,
you don't
but it
have
doesn't
to.
say assessor, so that's where I'm, unless the 106.07 is assessor.
That's what it's referring to
Okay,
as assessor.
'cause I was confused. Okay. That's it.
All right,
At least for the moment.
so I'm sorry.
No, I'm good.
One more question, go ahead.
No, I'm just saying, these were all basically state statute changes. Okay.
Correctly.
Yes.
Yep,
Right.
they were. I do have Ms. Rosario is not feeling well, so she's going to hold her item. It was on the agenda to present, time permitting, but it is action item tonight as well. So the next item was for Ms. Rosario to present the item, but she'll present it this evening, and I certainly hope she feels better because
Can I ask a question about that?
absolutely, if I can answer it, I will.
I know it's a board member brought it to discuss, but if we have it tonight, yeah, we can have discussion, but, I was well prepared to discuss this today for a workshop.
Me too. So do we have it as an action item tonight
It is an action item for this evening.
without discussion?
It will be, once it goes to the floor, that's when that discussion takes place. So there won't be a vote without having the discussion, unless you all choose not to have discussion.
No, there will be discussion, I'm
Oh,
sure.
I'm sure there will be discussion.
I just, I was hoping we could discuss it this afternoon so we could get some of this. I kind of want to get a feeling of what's going on with the board before tonight on this.
Yeah, I agree. I mean, it's a lot easier to discuss it in this setting, and people perhaps are a little more forthcoming, even though it's all public, as opposed to tonight, and I guess there's really nothing I guess we can do unless Ms. Rosario is willing to pull it until the next meeting, the next workshop and meeting.
I
Mrs.
cannot, she is the maker of the item, and out of respect for the maker of the item,
No, I get it.
So perhaps maybe what we can do to resolve this is have that conversation this evening, that because we weren't able to discuss it at workshop, as we were all intending, where we thought would be an appropriate setting before it was brought for action, that we would like to recommend that it be delayed till the next meeting.
Oh, I don't know about that. I think it's a timely.
Well,
Well,
that's
we
the
either
board's
discuss it
decision.
at 9 o'clock tonight.
and
Yeah.
the
Or
only
10
thing,
o'clock tonight.
once
That's the board's
that,
decision.
once the meeting opens this evening, that agenda, the items belong to the 5 board members, and what you do with them is what you do with them.
Okay.
So,
I just had a question that I really wanted vetted before tonight, because I really felt like I needed a clarity on a certain term that comes up all the time when you're looking at these statutes. Am I free to discuss something or add a discussion item?
I don't see why not.
I just want the clarity of instructional materials. Because there are laws and statutes, and this is a concern for instructional materials. So I just want to have a short discussion about that terminology.
so through the chair, is that right now?
That's what I'm asking.
Okay. And Suzanne can feel free to jump in at any time. Instructional materials is our core curriculum that we put in front of children. It is the materials that are being used to plan the lessons with the confines of a classroom. It is approved as a public school system. We approve that curriculum in which all students are exposed to our core curriculum. We have a process in place where it is vetted. We're all very familiar with that process because we went with HMH because our first product, Amplify, wasn't available. And then this board took a pause in the purchasing of curriculum until Amplify at the very last minute was approved. So we're familiar with that process. There is an appeal process which is in place for that particular approval of that content. Now, to speak specifically, that's not a library book,
That's what I
if
want to
that's
make a
what your question is.
distinction between. Is a library book then defined as an instructional material if a teacher can check it out and use it in their classroom for instruction?
There's not a library book for core instruction that's going to cover an entire class set. So a core instruction is we're all going to be covering this particular story, or we're going to do a novel study on a specific book that everyone has in their classroom. So I don't think it's odd to see novel studies taking place.
Oh, yeah.
That's not within the media center. I'm sorry, we call it library. That's not in the library itself. So the way libraries are working here is a go check out interest book, not at the drive of the teacher.
Well, and the reason why I bring this up, board members, is because we do have a policy in place for instructional materials. However, where I was searching and searching and searching for, I could not find a policy that's in place for an objection to library book or media book, whatever you want to call it. So that is where I was having the problem with trying to define all this. Ms. DeGrasse is raising her hand.
And I'll just point you back to the information that Mrs. Dampier reviewed with everyone. One of the proposed revisions to your policy is in your definition section 0100, and there is a proposal for a definition of instructional materials. And it is just as Dr. Moore was talking to you, what the definition, the proposed definition in this new policy piece means items having intellectual content that by design serve as a major tool for assisting in the instruction of a subject or course. And then it goes on to give you some examples.
And that is why I wanted this very clear, that the board understand the definition of instructional materials and where do library books fit. Because we definitely have a policy and procedure for what to do if you have an issue, a parent has an issue, or a board member has an issue with a particular book, right, that is an instructional material. The question I have is, where in our policies do we have anything that tells us exactly how we deal with the library books? Exactly.
I don't think there's a policy, but there are statutes that do address.
There are statutes. My question is, what's the procedure?
Oh, procedure, yeah.
That, we don't have a policy for a procedure. That's why I'm saying that.
We don't.
No. And my concern is, maybe we should have a policy of how somebody objects to a book. Is it done by email, one at a time? Is it done by presenting it at citizens' input? Is it done by sending a list of all the books at once to the superintendent? Is it done by having a meeting with the superintendent? Is it a parent going to a principal? So I couldn't find in all of our policies, I looked, I couldn't find an exact, and you know I was questioning that all week.
No.
I couldn't find our policy that we have in place on how someone does that.
I could tell you, I'm thinking as, middle school principal and high school principal. I'm going to speak as a mom right now. If I didn't want a child checking out a book, I would tell my child not to check out a book. But that doesn't mean I'm going to override somebody else's decision on that. I don't know, I think we could get into 300 policies and procedures, but, what is it that we're trying to accomplish here with all of our students? And I understand what you're saying, but, just because one parent objects, that doesn't mean the rest of them object, so.
No, but let's get down to specifics. If a parent feels that the definition of the statute, right, about profanity has been violated on a book, let's say, what does that parent do, and what's the procedure that a principal or the superintendent takes to determine whether or not that book fits the definition of the statute?
You're talking library book.
Yes.
So I hear you actually asking two different things.
Yeah.
One is, what's the process? The other is, what definition does it fit? Those are two different things.
Yes and no.
The process, I would think, and I'm sure, all of us have had a lot of conversations about this lately and a lot of conversations with the superintendent. Until this moment, I'm not clear that the process would have been any different than for any other dispute or disagreement or grievance you have at a school. If I'm upset because my child's curriculum, there's something in the curriculum, if I'm upset because of how my child is being treated, if I'm upset because the lunchroom isn't honoring special meals, whatever it is, my process is I go to the school, I go to the principal, I say, this is a problem, how can we work this out, how are we going to handle this? I'm not sure that I see where this process is any different than that process. As far as process goes, you're also asking about how do you decide if it meets the definition in a statute. That's a different question. That's a legal issue. That's not a parent issue. That's a legal issue. That's what we have legal counsel for. But the process for expressing a grievance about how something is happening in your school with your child is to go to your principal. If you don't get satisfaction from your principal, you go to an assistant superintendent. You go to Mr. Meyer. That would be the process.
Oh, okay, that's not what I'm talking about. I'm not talking about the side of the parent, I guess. Let me clarify that. I'm talking about, let's say this book, like you said, and I see the attorneys wanting to answer. Let's say that this book is a concern to a parent about the statute on profanity. Okay, let's just give that, I don't know, that might come up tonight. So if that's the case, who makes that ultimate decision? In other words, what process do we have in place that decides who gets to define that it violates the statute? That's what I'm asking.
And if I may, you do have a general policy, 9130, regarding public complaints. And that particular policy addresses a myriad of types of complaints, right? One of the categories included in that particular policy has to do with matters regarding the educational program. So if it doesn't fit neatly into any other category, this is like, I don't want to say a catch-all, but this is the catch-all. If it's about the educational program, this is where you would look to process that complaint. And it refers you back up earlier in the policy. It says, in the manner prescribed in the matters regarding an instructional staff member. So there is a step-by-step, if you will, of who you go to. There's a first level, there's a second level, there's a third level.
What policy is that, Suzanne?
9130. The title of that policy is Public Complaints. There are other types of complaints also addressed in that particular policy, but there is that general educational program that, Mrs. Berenborg, that I would say, if we don't have a specific process in place, this would be the general where we could go for a step-by-step, who do we go to, and then what are the steps to get through.
And the reason why I bring this up is because with the former one that you brought up, the example that you brought up with Amplify versus HMH, there was a process in place that was clear and defined. We bring in the mediator, or was it called a mediator?
Hearing officer.
Hearing officer.
Yes, hearing officer.
And the hearing officer makes the ultimate decision.
Made a
That's clear.
recommendation back to the board.
That's why that's why I asked my first question about library books being instructional materials. So we don't use that process then for library books. Okay?
Correct.
Correct.
So now the next question is, because there are not just one book that's being questioned, but several books.
58.
And we have to tread, I think, very carefully on this. And I want to make sure that we're very clear as to what the process is so that books aren't just being taken away quietly and removed, but we're being very transparent in how it's done.
So through the chair, just to respond to that, the only process that we're in the midst of now is to look at the statutory requirement around, are those specific books aligned to the statute around pornography, around vulgar, explicit, inappropriate, age-appropriate language. That's the only any other content, any other issues within those specific books is not anything that we are reviewing. This process does speak specifically to working through the school, which is 9130, making the school, then you take it up to the assistant superintendent, then ultimately myself. So if there are issues with books around racism, if there is issues around gay or lesbian, that is not explicit in terms of the content, then that would be the appropriate process for parents to follow.
I just want to make sure we're very clear on this.
Yeah.
And
Yeah.
I think you make a valid point in terms of moving forward. This is the process in order to follow. I can use an examples, and I know Dr. Jones is biting to speak.
Don't worry about me none.
But you clearly define the process. There are materials that were put on the shelves in which the process to put them on the shelves
Yeah.
wasn't followed.
We need to make sure that we're
That
obviously
is
showing
the
that up too.
appropriate
Yes.
response. And I will be honest with the board. This will not be the last time we find a process not being followed.
Correct.
That's just the work of transformation. But you don't hide it, you don't sneak it
Right.
away. The truth of the reality is, this school system has that link of all the books in our library publicly available. I can't find another superintendent who's willing to do that. So we are leading from the front here, which sometimes is uncomfortable, but that's fine too. And we don't hide or modify or shift anything other than the simple fact, we're going to look at what the statute says, we're going to align ourselves to the statute, but we're not banning books. We're not taking things off shelves. We're going to ensure that all means all, and all of our children have access to the information, and teachers aren't prescribing any one particular book to be used. And if a parent does feel uncomfortable about that, there's a process
Sure.
for that parent to follow.
Just procedures manual section is 2000 program. Selection of instructional materials and equipment, criteria for selection of equipment. Then D, procedures for selection of library or media center materials. Curriculum and Instruction Department, in cooperation with the committee, shall be responsible for the selection of all materials housed in a library or media center. I never had the CNI help me choose books for a library. You know what I mean?
No, absolutely, no.
Okay, all right, I'm just being transparent here. But that's a lot of work on CNI. I mean, you're going to tell them that they have to help choose all the books in the libraries
No.
now? Okay, good.
No, not at all. Through the chair, we'll have a very diverse group looking at when we're purchasing materials for the upcoming school years. Is it relevant? Is it what kids want to read? And is
Okay.
it aligned to the statutes before we put them on the shelves?
And I'd like to also know, how often are kids going to the library and checking out books, period?
And I think that's part of the item that Ms. Rosario is bringing forward. And
Yeah.
I can tell you, Mr. Bass can tell you from someone who just built a school in another county. I can tell you from a district that had 326 schools. It should be an innovation space. It should
Absolutely.
be a media center. The volume of books purchased when building a new school is significantly different from what we see. So part of that item this evening, which I completely agree with, is to look at how we're using those
That's okay.
specific spaces to ensure kids are in fact ready to be successful. And that's way overdue.
And all the emails we received, something about the AR. Well, high schools aren't using the AR. We stopped funding that 4 or 5 years ago. Middle schools are kind of using it, but not aligned to any curriculum. And they've chosen another one they like a little bit better. So,
Ion.
if they're concerned about people using the AR books, none of them are saying you have to read this or do this. We used to do it probably 10 years ago, but that's not even used in the high schools.
Right, and I would inform the board, I do it regularly, because we now are so committed to being at the standard and having a core curriculum within each specific area, you're seeing a level of alignment that you haven't seen ever before.
Yeah, I know.
In terms of what teachers are teaching, there is a process in place to approve curriculums. What we saw pre-pandemic was very, very concerning and significantly below the rigor of the standard. It's not what we're seeing now. And I'll say it again this evening. In the 10 years that I've done transformational work, the improvement of the quality of instruction from the beginning of this school to what I was seeing just this morning in schools is truly amazing. You are seeing instruction improve by leaps and bounds. And you see a level of alignment that takes 4 or 5 years to get to. So what we're doing in our schools in terms of inspecting what we expect is significant, and our teachers are delivering. And because of that, you're probably seeing a lack of use in media centers because we got a job to do. We got to move kids. We got to make sure they can maximize their full potential. And what's in the media centers isn't something that today's kid really is attracted to. Now, it should be the heartbeat of the school. It should be the hub of the school. We want to go there and work on projects. We have great people that are staffing them, but we have to support them in the creation of the process and the space to bring those media centers back to life.
Yep. Okay, thank you. I just want a very, very clear definition of what we're dealing with.
I agree.
On this. Okay,
I
thank you.
agree, and we'll push that out. I do have one item that I referenced the board in email. Working with the NAACP, we will be meeting coming in December with their members of their executive committee as we begin to plan for next school year. We're interested in having a number of small meetings to identify what our agenda would be, what targets we would like to hit, what areas of the joint plan we may want to shift or modify. I communicated to the NAACP that I think it would be valuable to have a representative of the board participate in those sessions. This would be, at this point, under the umbrella of mediation. NAACP has new counsel, but after they're currently meeting with their new counsel to get up to speed, and we plan on having these meetings in December. So this would take place over the course of December. So when we all come back together in January, as we did last year, the entire executive committee and the school board, we've already kind of normed, and we've had a working team presenting collectively to both the board and executive committee on the shifts or modifications or changes. I know Mr. Barefoot responded to my email. He recommended Doc Jones. Doc Jones said that she would be interested. If there's consensus from the board, then we can do that. If not, I can bring an item and the board can select somebody. But I just wanted to put that in front of the board.
I also responded to your email. I didn't realize that the idea was to nominate someone via email. I thought that was a conversation.
No, just
we would have.
the email was to
I
have
agree.
this
To just
conversation.
say, can we have
If
this
there is
conversation?
consensus, there would be fine. If not, I will more than happy to bring an item so we could, that's the only way the board to take action unless it's absolutely go for it, Doc Jones. Or,
If she's willing, I'm happy for Doc Jones to
She
represent us
tends
on that.
anyway.
I would be honored, thank you.
The only other concern I had is a board member brought up concerns about us attending committee meetings. So would that be a concern of the board member about attending committee meetings? You sent us something that a board member was,
no, that, through the chair, and Suzanne, help me if I go astray, those were meetings in the community or district staff committees. I just wanted to send that. There is no issues with any board member as it relates to that particular concern. But I did want to share that information with the board.
okay.
Correct. There would be no problem with an individual board member attending a mediation session in pending litigation. It's fine.
So I do want to announce the winner, which is Sniffen Spellman, was the highest ranking firm. So Mr. Fagan, Mr. Greston, and myself will be working diligently to bring an item to you on the 29th. And absolutely thank both firms. Very, very good in terms of their presentations and the quality of support. We're looking forward to getting that work done. And as we do close this meeting, let me remind the board, we will be celebrating our retiring school board member over in our little area over there
She's
for.
a school board member
No,
now.
no, school board attorney.
That she's going to run for one.
That's what she's going to announce. That's her retirement. No, I'm kidding. She's like, no. Our school board attorney in our little room over there. So we just want to take the time to celebrate and acknowledge all of her contributions to the school system for how many years, Suzanne? A really long time.
On April Fool's Day.
Yeah.
12 years.
Yes, I looked it up.
And you worked before that, kind of coming in and out, I remember, yeah.
Yes, Russ Peterson and
Yes.
assistants for a couple of years.
We're going to talk about you again tonight, so.
Okay, we're all done. Meeting adjourned at 4:04.
Thank you. And we'll be back at 5 by the